Good morning, everyone. We have 6 cases on today's argument calendar, and we'll begin with 4 consolidated appeals, numbers 24-3317, 25-1072, 25-1076, and 25-1112. Illinois Tamale Company versus LC Trademark and others. Mr. Handelman, nice to see you. Whenever you're ready.
May it please the court. My name is Jeff Handelman, representing Little Caesars. The outcome here turns on 3 primary determinations. First, are the plaintiff's alleged trademarks valid? If not, the plaintiff cannot prevail on the merits. Second, if the marks are valid, can the plaintiff show likelihood of confusion? If no likelihood of confusion, the plaintiff cannot prevail on the merits. And lastly, does the defendant's use of the phrase 4 handheld pizza puffs constitute fair use under the Lanham Act? Fair use as an affirmative defense overcomes a claim of infringement. Turning first to the issue of validity, the district court applied an incorrect legal test of genericness.
Before you get to that test, you have correctly pointed out that the standard for a preliminary injunction for likelihood of success is not better than negligible. Is it your position that the district court applied the better than negligible as opposed to the more than a mere possibility of success?
Our view is...
It's hard to tell from the opinion.
Yeah. Under the Grubhub case, this court clarified the standard for satisfying...
Yes, I don't disagree with you on that, but I can't tell if you are arguing that the district court applied the wrong preliminary injunction standard at the outset, or if you are not contesting the standard, that standard that the court applied.
I would have to go back and read the opinion.
Okay, that's fair.
Yeah.
Maybe on rebuttal you can let me know.
Very well. Thank you, Your Honor. But what we do contend is that because there was an error of law as to the test of genericness that was applied, that this court should correct that error of law and reverse the finding of genericness. In particular, the statutory test under the Lanham Act is what is the primary significance of the term in dispute? And that's the test that this court has consistently applied. However, the test the district court used was whether the term in question is, quote, the exclusive descriptor of the goods. That language came out of dictum.
If we agree with you on that legal test, do you automatically win? Don't we have to continue to go through and look at the other elements?
Well, yes. If the correct test is applied, the primary significant test, it's our position that the evidence overwhelmingly shows that the marks at issue are generic. And so, look, for example, if the correct test had been applied, the primary significance test, we submitted a consumer survey measuring the primary significance of the terms pizza puff and puff. And in that consumer survey, 83.3% of the respondents perceived pizza puff as generic. Only 12.7% perceived pizza puff as a brand. And likewise, in the puff survey, 80.3% of the respondents perceived puff as a generic term, whereas only 14.7% perceived it as a brand.
Mr. Handelman, you are appealing the puff determinations by the district court as well, but you're here on an appeal on a preliminary injunction, and the court actually denied the preliminary injunction as to puff. The court granted it as to pizza puff, but denied, unless I'm missing something, or there's an order that wasn't here, the court denies plaintiff's motion based on the defendant's alleged infringement of the puff mark. So I was a little confused why you're appealing that or how you can appeal that.
We were appealing from the grant of the preliminary injunction as to 4 handheld pizza puffs. We were enjoined from using 4 handheld pizza puffs in connection with the product, and so we brought our appeal.
I understand that, but you also have a section dealing just with puffs and arguing that puffs is generic, that the district court got that wrong. But I'm not sure, given that you're here on a preliminary injunction appeal and the court denied the appeal as to puffs, how you can bring that aspect of the appeal.
Well, I think that what the court said, it found no likelihood of confusion as to puff and the phrase, but it found likelihood of confusion as to pizza puff and the phrase, if I recall correctly.
That's correct.
And so we're appealing from the grant of the injunction, and we're saying that the injunction should have been denied, first because both pizza puff and puff are generic, and
But
second...
I guess that's the question, the puff piece of it, because pizza puff goes together.
Yep.
There were several challenges below to pizza puff and to puff. And the blue brief makes an argument that the district court erred as to puff. And I'm just not sure how you can bring that, given that you prevailed on that aspect of the preliminary injunction.
Well, we also believe that the injunction as to the phrase 4 handheld pizza puffs should be reversed because both marks are generic, putting aside the issue of confusion. If you find both pizza puff and puff generic as a threshold matter, the court doesn't even have to reach the issue of confusion. So our primary position...
Can I tell you what can I try the same question?
Please.
Okay, I think, you should correct me if I'm wrong though, okay, and your adversary can do the same. I think the reason that I understand from the briefs, I'm confused on the same point, okay? I think the reason that you're arguing as to both pizza puffs and puff or puffs is because your adversary is taking the position they're both protected. And so what you're doing is you're advancing an argument that's addressing both marks, including the use of puff in isolation in the phrase 4 handheld pizza puffs. Is that correct?
That's correct.
That's why there's a portion of your brief that is isolated to the word puffs.
That's correct, Your Honor, as to the question of confusion. But then also, because the court granted the injunction as to the phrase, we're saying that injunction should be reversed, there's no confusion. But also, that injunction should be reversed because the underlying asserted marks are both not legally protectable. And so the court erred in not finding that those terms are generic, and because that's a threshold issue, if the court finds that both pizza puff and puff are generic, the plaintiff cannot prevail on its claims irrespective of confusion.
But if we just find puff is generic, that's not sufficient for you to prevail. We have to address pizza puff because that's what the injunction was about.
Correct. And so our position is, I'm sorry.
No,
Our position is that both marks are generic. They're both dictionary words that are defined in the dictionary. There were separate surveys on each mark showing over 80%.
That's where I want to go now. You were headed there before, the
Yep.
survey results. Is your contention with the way the district court handled the survey results? The district court said the results were compelling, but then found that they did not win the day. Was that move, in your view, legal error or some sort of factual error, the court's response to the survey results?
I think the response to the survey results ties in with the incorrect legal test that was applied. Had the court applied the primary significance test, the primary significance survey results would have directly supported a finding of genericness because the court found the survey was compelling, a factual finding. But because the court applied an incorrect legal test, this are there other terms available, the survey was given inadequate weight, and we believe that under the correct legal test of primary significance, that the primary significance survey of over 80% of this is a common term, not a brand, overwhelmingly establishes genericness. So we see a direct link between the legal error in the standard and the treatment of the survey results, but we think that the court's finding that the survey was compelling And bear in mind that the plaintiff retained a marketing expert to critique the survey. And also, Hal Porat, the gentleman who conducted the survey, testified at the hearing at length in front of the district judge. So the district judge had a chance to question the expert witness, review the criticisms that the plaintiff came forward with, and still found the survey to be compelling, a factual finding with which we agree, but the legal error, we believe, caused the survey to be given inadequate weight. With respect to, briefly finishing up on validity, so we have the survey, but that's not all. We have industry use evidence showing that both Pizza Puff and Puff are extensively used in a generic fashion in the restaurant and food industry, and in Miller Brewing and in the Warehouse Shoes case, which Judge Flaum authored, industry use of this type was given weight where this court found the terms at issue generic. We also have dictionary definitions, which are not required, as the court knows, for a finding of genericness, but when you have a common English word in a dictionary with a definition encompassing the goods at issue, that's compelling evidence of genericness as well. So it's our position that this evidence, taken together, establishes an insuperable obstacle. That's what Miller Brewing called genericness, an insuperable obstacle to a plaintiff's trademark infringement claim. And then turning to confusion, the district court correctly found no likelihood of confusion between plaintiff's marks and Crazy Puffs, but erred in its analysis of confusion as to the phrase. First, addressing the Crazy Puffs mark, the district court correctly applied the law of this circuit that the dominant portion of the mark should be given greater weight in the analysis. Here, Puffs, as part of the Crazy Puffs mark, is disclaimed. The trademark office required us to disclaim it as an unregisterable component. But not only the disclaimer, we have the same evidence on the validity part of the case, the industry use of Puff in a generic fashion, the dictionary definitions of Puff encompassing these goods. A Puff, it's not that the product is puffy, it's a Puff is essentially it's a noun that refers to a small dough-based food item that is typically filled with ingredients that can be either sweet or savory. Thank you. And so just to wrap up on confusion, the dominant portion is crazy. Puff is disclaimed. It's defined in the dictionary. Crazy builds on the goodwill Little Caesars has in the crazy bread and crazy sauce and crazy combo marks. It has many crazy marks. Viewed as a whole, the district court correctly viewed the marks as a whole, gave dominant weight to crazy, and found that while the plaintiff's mark began with the descriptor of the food item and end with Puff, in contrast, defendant's use of crazy sets it apart from plaintiff's Pizza Puffs mark and ties it to defendant's crazy marks, no confusion. And likewise, the district court found no confusion between Crazy Puffs and Puff, saying Crazy Puff creates a different commercial impression than Puff alone because it implies something more, particularly when used with the defendant's trade dress, the Roman man, the orange trade dress, and so forth. So for all of those reasons, the district court correctly found no likelihood of confusion, and that finding is not clearly erroneous and should be affirmed. And I'd like to reserve my remaining time for rebuttal.
Okay, very well. Thank you, Mr. Handelman. Ms. Thompson, nice to see you whenever you're ready.
Good morning. Elizabeth Thompson on behalf of Plaintiff Appellee Illinois Tamale Company. Since this is a cross appeal, if your honors would allow me to reserve a minute of time to address any issues that are raised on our cross appeal, I would appreciate that. Thank you. I want to start by looking at the dictionary definition that the district court relied on. Merriam-Webster.
Before we get there, I
Yep.
want to talk about the general standard for
Sure.
preliminary injunction.
Yes.
You've argued that the standard should be better than negligible, but the Supreme Court has rejected that. I know there's some old case law of ours that says that, but it's pretty clear that the standard is more than a mere possibility of success.
Yeah, that's correct, and I think that we have established more than a mere possibility of success. And I know that you asked counsel a question about whether or not the district court relied on that better than negligible standard. It did not. If you look at that court's opinion, it never uses that language.
It
And
doesn't use either one. It just says a likelihood of success.
It does not use either one, but I think that we've established under either clearly under the lesser standard, but also under the more significant standard, we've established a likelihood of success. And so I don't think the district court relied on that wrong standard. So as I was saying, Merriam-Webster defines puff as a light, round, hollow pastry. Il Taco's Pizza Puff is an iconic Chicago food and is made from a flour tortilla filled with ingredients typically found in a pizza. Little Caesars product is, in the words of the district court, a pizza muffin or a pizza cupcake or a pizza bite. Neither product is made from puff pastry. Neither product can be considered light by any stretch of the imagination. And neither product is hollow. And if you're not familiar with the products, there's pictures of both Little Caesars product and Il Taco's product in the appendix A23 for Little Caesars product and A25, A309 through 310 for Il Taco's product.
In determining the validity, the court applied the exclusive descriptor test, language picked up from Thai. Again, the Supreme Court has made clear that the test is primary significance as opposed to exclusive descriptor. The district court applied the wrong test here. How can you prevail given that it applied the wrong test?
So I don't agree that it applied the wrong test. I think that the language that it picked up from this court's prior decisions, which is also in a number of other decisions that we've cited in our briefs.
Are you defending the exclusive descriptor test, or are you saying that the court applied the primary significant test?
I don't think the court used the words primary significant test.
It's correct.
But I think that it relied on language from this court's and other decisions that talks about the exclusive descriptor, which I think, given what the court did then in looking at all of the different evidence that Little Caesars put in front of it, that it doesn't matter whether or not it used the words primary significance
Do
or
you
exclusive
agree primary
descriptor.
significance is a test?
I do. It's in the
Okay.
statute, yes.
Because
Go ahead. Go ahead.
I'm wondering how you're able to say that it didn't exclusively rely on the exclusive descriptor test when it has a clear holding that, you know, other people are able to sell products without using the word puffs, similar products without using the word puffs. And so that, in the district court's view, showed there was an ability to market a product without the word puff. It seems by my reading the district court did go in on the exclusive descriptor. Where are you seeing the analysis showing something different?
So I agree with you. The district court did look at other competitive products that are very similar products like Hot Pockets that obviously do not use the language or the words pizza puff to describe their product. The district court did do that, absolutely. But the district court also looked at the survey evidence, and I know that you all talked about that. It found it somewhat compelling, but also looked at other cases that said 10% can be enough to show a likelihood of confusion.
Well, when you say other cases, the court really only quoted, again, Thai.
I don't think in the survey, when it was talking about the survey, it was
when
quoting
the court
Thai.
mentioned that even 10% could be a problem. You know,
It-
that's a quote from Thai in the district court's opinion.
And if you give me just a second, because there were some other,
it's A2 in the supplement, and
the
the court
bottom.
quoted, it's the last paragraph. And the court only relied on Thai.
oh, and I'm sorry, I was looking for the cases we cited on page 3 of our gray brief. We cited a number of other cases since Thai that have looked at that language, the exclusive descriptor language, and in applying the primary significance test, it's one of the factors that both this district court looked at and other courts have looked at in determining whether or not a mark is generic.
But the court goes on to hold, following what Judge Jackson-Humey just pointed to say the evidence calls into question whether the trademark has gone so far toward becoming the exclusive descriptor of the product. There's no mention or analysis of primary significance here.
I don't disagree with you that the district court does not use the words primary significance.
But even without using the words, it's not using the concept. Primarily significant is different than exclusive.
I don't disagree with that either, but I think that it is using the primary significance test. When you look at, the district judge looks at the dictionary definition, the Merriam-Webster dictionary definition. One of the issues with the dictionary definitions that were submitted by defendants in this case is it was essentially one crowdsourced dictionary definition that they found in various different sources and gave to the court. The court, although doesn't necessarily use the language, I'm not looking at those, I'm looking at Merriam-Webster, he does look at Merriam-Webster, which I think was the appropriate thing to do here, and he does analyze a number of the other things that defendants submitted here to try to establish that the primary significance of Pizza Puffs was a product.
I have a question about the crowdsourced dictionaries. Normally in our business, they're not our go-to, but here in trademarks, our job as a court is to determine from a consumer's perspective what a consumer thinks something means and whether a consumer considers something generic versus a brand name. So why wouldn't a crowdsourced dictionary be precisely the kind of evidence that could help us determine whether consumers think something is generic or not?
I think the problem with the crowdsourced dictionary in general is that it is something that can be edited by anybody, and we don't know where it's coming from. Mm-hmm. I think when you look at, and especially here when we do have a more reputable dictionary that does define the term, I think that should control over the other things. Also, and I think as counsel conceded, the dictionary definitions alone are not going to be dispositive as to what the primary significance of a term is. But it really was one single crowdsourced definition. You don't know where it comes from. It's just then cited multiple times.
Ms. Thompson, can I ask you a question about the arguments that Little Caesars makes about fair use?
Yes.
On Pizza Puff? The fair use affirmative defense, as you know, has 3 prongs to it. I want to focus on the second one.
Yes.
The descriptiveness aspect.
Yes.
What, in your view, is the legal standard for measuring descriptiveness for purposes of applying the fair use doctrine?
I think it's the same as measuring descriptiveness as a trademark in general, whether or not the term describes the product. It answers the question, what are you versus where do you come from? And in this case, and it's a question of fact, so I think that this court reviews the decision of the district court on a clear error standard, and I think that applies to everything that we're talking about here today, because this is in front of this court on a preliminary injunction. The district court had an evidentiary hearing, took testimony from 4 witnesses, so on all of that,
legally, you think it just mirrors the descriptiveness aspect on the protectability side of the analysis?
I do. I think it has to be descriptive of, and in this case, it's descriptive of the defendant's product, right?
Okay, can I ask you a hypothetical?
Sure.
Okay. Take the ad that has been the one of real focus, where Little Caesars has crazy puffs, and then in that subordinate text.
Yes.
Okay. And suppose the subordinate text, instead of saying 4 handheld pizza puffs, said 4 handheld small puffy pizzas.
Okay.
Okay.
Yes.
Descriptive?
I don't know, because I don't know how they're puffy, and I think that's the problem. Is that, and what we've raised to the district court, and also in our briefs to this court, is there's nothing about Little Caesars product that is puffy. And if you look back at the dictionary,
other than the fact that they look like a muffin, and it wouldn't be crazy to call a muffin kind of puffy in appearance.
I guess I don't follow that that line of reasoning. I don't think that a muffin is necessarily puffy. Puffy is, at least when you look at the definition from Merriam-Webster, and as I understand the term, is something that's light and airy.
But hang on, in your answer to Judge Scudder, do you run into our precedent that whether a use is descriptive for the purpose of fair use analysis it doesn't turn on the accuracy of the description. It turns on whether something's being used in a descriptive manner. So a company could describe something poorly, which is what you're suggesting.
Sure.
How on earth could they call it a small puffy pizza, or a pizza puff is more like a cupcake or a muffin? But that goes to the accuracy, not the manner in which the company is describing or using the words.
I think I don't disagree with that, but I think focusing back on the ad that Justice Scudder was just looking at, it does say 4 handheld pizza puffs, and then underneath that is additional descriptive language that says what it is. So the
See, that's why I tend to think it's descriptive. And all I was doing with the hypothetical is just coming up with a play on words for something. And I think why would they say something like, small puffy pizzas? I think to try to convey to somebody that if they're going to buy the product, it's going to be sufficiently filling. That way you get 4 of these things for $4, and it can kind of serve as lunch.
It could
That way.
definitely.
I mean, that's what I think is. I mean, I'm just looking at it and trying to think what is the term trying to connote? It's trying to connote a description of what somebody's about to buy.
Well, respectfully, I disagree with that. I think that the language underneath it is a description of what the person is trying to buy, regardless of whether or not the mark is, or whether or not that language could be considered descriptive for the fair use.
So how is that not fair use though? I don't know. That's
Well,
the
I
part
think
of
that and I'm sorry to interrupt.
No,
you.
go ahead. You're fine.
I think that they haven't met the other elements either. Although the district court focused only on the descriptive nature, they are also using it as a mark, and we've cited.
No, I know I know it's a 3-pronged test. You're right to emphasize that. Just focusing on that descriptive aspect of it. When they say 4 handheld, that part of it definitely seems descriptive to me.
I agree, and the district court also.
And then the
went through
words
that.
below it, the ingredients seem descriptive, like
Correct.
what it contains, pizza filling and what have you.
Right, and I think that, and I'm sorry if I didn't mean to
You're fine.
interrupt.
Keep going.
I think that in the district court, this exact conversation was had with the district court judge, and he said, I 4, yes, there's 4 of them, no question. Handheld, that means you can hold them in your hand. Pizza, yes, they're pizza because they have pizza flavors, ingredients, and all of that. The issue the district court, and what we're arguing to this court had, was with the word puff. He said, how are these puffs? And that was not a question that could be answered by Little Caesars.
But that seems to go to accuracy. The district court seemed to say that it's not apparent that the defendant's product is a puff, like the plaintiff's product. It didn't address the more general, this is being used to describe a characteristic as opposed to being the same product, which is not what you're allowed to do under the law for fair use descriptiveness.
So I want to be cognizant of my time. I don't think that it's descriptive of plaintiff's product either. So I just want to be clear about that we've never made the argument that puff is descriptive of plaintiff's product either. But I don't think that you can use somebody else's trademark just and fall back on the fact that, it just wasn't a very good description of what we were trying to say.
But that's not what I'm saying. I'm saying the court seemed to think that it had to be a puff as opposed to have puff characteristics. And those are different. And that's based on the language in the court's opinion. That's what it seemed like the court did.
I actually think that if you look at the transcript of the preliminary injunction hearing and the conversation the court had.
I'm looking at the court's ruling, which is what's
Sure.
on appeal.
Absolutely, it is. But I think that what the court was doing was saying that there's nothing about this product that has the characteristic of being puffy.
It's hard to take that from the order. It's hard to see that.
I understand that, and I think that there's more information when you look at the preliminary injunction hearing, but.
This is the part of the
Yeah,
order
again, we
where
have to
the,
look at the order.
this is the part of the order where the district court said it looks to the district court more like a mini pizza,
Yes,
a pizza muffin, a pizza cupcake, or a pizza bite.
yes.
Okay? And you think, well, I mean, maybe, but why doesn't it also look like a puff?
I think
In
the
other
question
words, I
just
don't,
comes
I,
back
I'd
to
say
which
like, could you call that thing a mini pizza? Yeah, probably. But why couldn't you call it a pizza puff too?
well, I think you can't call it a pizza puff because that's a trademark term, and the
Well,
puff.
under the fair use doctrine,
Yes, I
descriptively.
think the problem with it is that what is a puff? A puff is a light, round, hollow pastry. That's not Little Caesar's Crazy Puffs.
Okay, I'm gonna, any further questions? Okay, we'll give you the minute you asked
Thank you,
for.
I appreciate that.
You're quite
And,
welcome. Okay,
Thank you.
no problem. Mr. Handelman, you had some time left. You're welcome to use.
Thank you, Your Honor. Just very quickly, with respect to fair use, I think this court has made it clear that the descriptiveness prong requires only that the term describe a characteristic of the product. We would, in conclusion, this court should affirm the denial of the preliminary injunction as to the Crazy Puffs mark. The district court's finding of no likelihood of confusion is fully supported by the facts and the law of this circuit and is not clearly erroneous.
Were
And
you able, Mr. Handelman, during the time your opponent was arguing, determine if you are arguing the district court applied the wrong preliminary injunction standard, or are you not arguing that?
We're not arguing that. This court it quoted Grubhub saying that it is likely to succeed on the merits, and we're saying that the plaintiff is not likely to succeed on the merits. This court should apply the correct legal test of genericness on the issue of validity to reverse the preliminary injunction against the phrase "for handheld pizza puffs." The genericness test applied by the district court is contrary to this court's precedent. It's contrary to the statutory standard in the Lanham Act, and it's also at odds with the policy of trademark law to prevent the monopolization of common English words. The procedural posture of this case tracks that of Miller Brewing, which is where light beer was held to be generic for a type of beer, and also the Milmar case where warehouse shoes was found to be generic for a retail store selling discount-priced shoes. In both of those cases, the lower court found the market issue valid and then granted a preliminary injunction. And on appeal, this court found the mark generic, both light and warehouse shoes, under the proper legal test, primary significance, and reversed the preliminary injunction on those grounds. So we respectfully request this court to correct the legal error below and to reverse the district court's grant of the preliminary injunction. Thank you very much for your time.
You're quite welcome. Ms. Thompson.
Thank you. I appreciate the extra minute. I just want to very briefly address our cross appeal. We have cross appealed the district court's denial of the preliminary injunction on Crazy Puffs versus Puffs. As your honors have recognized, the district court did find that Puff was a protected mark. It did, however, find that there was no likelihood of confusion. We think we've submitted significant reasons why that decision was a clear error, not least of which is the actual confusion that we've submitted from numerous social media posts. And I think this maybe goes back to the question about crowdsourcing and isn't that the evidence of what the public thinks. I think that same argument can be applied to the social media information that we submitted to the district court, and the district court erroneously said he could not rely on. So for those reasons, unless your honors have any additional questions, we'd ask that the decision granting the preliminary injunction is affirmed and the decision denying on the use of Crazy Puffs is reversed.
Okay.
Thank you.
You're welcome. Ms. Thompson, thank to you and your colleague. Mr. Handelman, to you as well and your colleague. We'll take the consolidated appeals under advisement with thanks to both sides.
Thank you, Your Honor.
We'll move to our second argument of the morning. That comes in appeal number 251713, BBLI Edison LLC versus the City of Chicago. Okay, Mr. Bremer, nice to see you whenever you're ready.
Good morning, and may it please the court. I am David Bremer for the appellant BBLI Edison. Your Honors, in an attempt to control the use of foreclosed rental property, the city passed an ordinance that forces owners like BBLI to transfer their property, their money, to tenants who voluntarily choose to leave the property instead of accept a new lease. The main point of contention seems to be whether this taking of BBLI's money for tenant use is analyzed as a per se taking, and it is, because the tenant payment requirement harms BBLI's ability to use and lease its property. The appropriation of BBLI's money is treated as a per se physical taking, and that is the lesson of both the Supreme Court's decisions in Kuntz and Tyler. The tenant payment requirement at issue here interferes with BBLI's ability to use and lease the building. And under Kuntz, this is the link that triggers per se takings analysis for the monetary demand that BBLI is challenging. Once it is accepted that, as it must be, that this money is constitutionally protected property that is subject to per se takings analysis, the analysis is, as the per se label indicates, very straightforward. There's no compensation, therefore this is unconstitutional even if it's for a public use, and therefore the appropriate response is to reverse and remand the district court's opinion, and it can apply the appropriate remedy for this unconstitutional taking.
Mr. Bremer, what are the limits of your argument? You're arguing that the money here is a taking because it limits the use of that money, of what you can do or use it for with respect to the building. But it seems like if we agree that's a taking, that there are a whole lot of regulations out there about real property that have long been understood as okay, that this would overturn. So in other words, it seems like we would be opening up all sorts of landlord-tenant regulations, regulations as to buildings and money, to constitutional challenges, which would be very, very different from where the Supreme Court has been.
I understand your concern, Judge Sadie. I don't think that is would happen for this reason.
So what are the limits? Why wouldn't that happen? If you could, in answering that, please just tell us what legal principle limits your argument has.
Right. The limit is what I was trying to refer to earlier, that you do not get a per se physical taking, automatic takings analysis in a taking of money case unless the taking of the money also interferes with the use of real property. So you have a lot of monetary obligations that are out there. They're not going to be treated as per se takings. You might be able to bring regulatory takings.
Why wouldn't property owners start coming in all the time saying, well, that regulation that requires me to pay X or limits my payment that I can receive on X is taking away extra money that I want to put back into the property?
Right. And so user fees, taxes, those are not takings. That's money. So most of the things that you're perhaps, I don't want to speak for you, but user fees, permit fees, all these type of things that we're used to, those are not takings. The Supreme Court has held that. That's not what we're dealing with here. We're dealing with a one-of-a-kind, unique ordinance that requires the landlords to pay tenants who voluntarily choose to leave.
Why wouldn't this apply then to all restrictions put on landlord tenants in terms of amounts that they can charge for rent, etc.?
Well, because it's not rent control. It's different. This is, again, if I could explain a little bit more what's happening here. This is a unique ordinance in which the tenants get to choose to take the money or leave. There are relocation fee ordinances that have been upheld, but those have applied when the landlord is ending a lease and evicting the tenant, and so the tenant gets paid moving costs because they have to move. That's not what's happening here. They don't have to move. They're being offered new leases. What's happening is they get the option to take a new lease from BBLI or it's money. Give us a lease or give us your money. And so it's very unique. So I don't think the concern that these other things that have been generally upheld are going to be swept into this circumstance where you have this unique sort of a fee that's tenant choice.
Would it be unconstitutional if they were required to use the $10,000 for another place to live or to pay rent? So if the statute specifically said this $10,000 that you get, you have to use that for your move, for your next rent, for a down payment, etc., would it still be unconstitutional?
I think it would be a much closer case, particularly with public use and the regulatory takings analysis. But it wouldn't be if the scenario was still the same, that you had to offer them the lease or they could choose to take your money. It would still be a taking of their money in that instance, but it may be for a public use. And in this
Mr.
case,
Bremer, I had a similar question, and that is, suppose you add on to Judge St. Eve's hypothetical a program control requirement. And what I mean by that is that the $10,000, $10,600 would be paid to a tenant, but it would be paid to a tenant through like a direct reimbursement program where they had to come forward with a new lease agreement or a rider truck bill or something like that for moving expenses. And the reason I ask that question is there's a flavor in your brief, unless I've read it wrong, where one thing that seems to trouble your client is the lack of control. In other words, the $10,000 is given directly to a tenant that chooses to move, and there's no limitation on how that money could be used. It could be used for personal purposes. It could be blown at the casino. Anything could happen to the money. Have I read your brief correctly?
That is a concern, but it's not the only concern. The lack of control is a concern, but I would think even more importantly, and it goes to Judge St. Eve's question as well, the landlords in this context aren't causing the need for this payment. They are not. The tenants are choosing to leave and take the money. So regardless how they ultimately use it, and I think they should be controls because that goes to whether it's a public use and whether it's proportionality. Regardless of how it's used, the landlords are not. It's not like a normal landlord or tenant restriction that Judge St. Eve was talking about.
The reason you're pushing that argument is you're trying to distinguish the case from Ballinger. And you know Ballinger well. And Ballinger was a situation where I think it was the Ballingers, right? The military couple decided not to renew the lease when they came back from the military leave. And the argument out there in the Ninth Circuit was that, well, they're property owners. We'll give you time. Don't worry about the time. Okay. They're property owners. They have the right to do that. They're not evicting anybody. Just didn't win in the Ninth Circuit. So I think that's why you're here. Unless I'm hearing you wrong, that's why you're really emphasizing that the choice here is not made by the property owner. The choice is made by the tenant that chooses to move.
I mean, that's part of it, but that's not the only reason. I think when you look at takings cases in general, it's generally a factual determination, and ultimately it comes down to what fairness and justice requires in each case. And that particular fact that the need for this payment is not caused by the landlord is an important, regardless of Ballinger, it's an important fact about whether this comes within the takings clause or it's just a regular landlord-tenant regulation in which regular landlord-tenant regulations, the need for the regulations are caused by what the landlord is doing. Here, the landlord is not doing anything. They're just taking ownership. They step into the shoes of the owner. They're not evicting. They're offering new leases, and they're told, Well, the tenants can break their lease and take your money. That's their choice. So the landlord is in a much different scenario than, say, the Ballingers or the Yees in the rent control cases, because they are subject to the taking based on nothing except the city's will that it wants to give BBLI's money to tenants to use whatever they want to use.
Are you stepping away from your regulatory taking argument, or did you just choose to emphasize the per se taking when you approached?
Well, I'm not stepping away. I think
Okay.
it's the simplest.
Because I want to ask you about that then.
Okay.
It's the investment back expectations portion of the Penn Central test. What are we to make of the fact that your client bought in 2024, and this is a 2021 regulation? So help us with that.
Right, and that's an important question.
I saw your response in your brief. I think you're
Right.
going to have to go beyond that, because your client clearly bought a foreclosed building.
Right, I will, and thank you for that question. First of all, just to clarify, notice doesn't apply to per se takings analysis, so we're just talking about regulatory takings analysis. And our position is that notice is irrelevant also in regulatory takings analysis. In takings analysis in general, because notice goes to what you expect, as you mentioned, and what the circumstances are, and that is not an appropriate criteria for whether property has been taken. Your expectations, what you thought, what the city thought, shouldn't matter. But let's say
You said should not matter?
shouldn't matter at all. But let's say I'm wrong. Let's say I'm wrong, and you're under Penn Central, and the expectations and notice is something you might want to think about. That's a factual issue that shouldn't be resolved on a motion to dismiss like it was here. So even if Your Honor is correct, or you think that notice is important, it's one small slice of a bigger balancing test that's a factual inquiry that we haven't had a chance to develop any facts about what the BBLI knew or didn't know, what the city really intended or didn't intend. All those things should be resolved with some discovery so we can get to expectations and notice if, again, they actually matter.
How much of the Penn Central test did you need to plead facts supporting in your complaint?
I think you need to, as Yee, there's a footnote in Yee, I'm sorry, I forget the footnote, but the footnote in Yee basically says that you just need to plead a takings claim, and the theory of that claim doesn't have to be within the complaint. And so there's plenty of facts in this complaint, but the facts of what people knew, how much they bought, and how much they paid, all that kind of thing, that's not in there. But that's not needed to bring a claim that you've taken our money, our private property.
Mr. Bremer, suppose that the case was not dismissed on a motion and it did go into discovery, hypothetically, okay? And suppose in the discovery that the evidence showed that 95% of payment recipients under the city's ordinance used the payments 100% for housing relocation purposes. How would that factor into an analysis as you would see it?
Well, I would think that might particularly affect the regulatory takings analysis.
Yeah, it's not, I know you're on the per se, on the regulatory
Okay.
taking side. Yeah, right.
Okay. Thanks for clarifying. That would affect the analysis for sure. That would affect, assuming you're applying the three-prong Penn Central, that would affect the maybe the impact and the character of the government action. But we don't have that, and that's part of the problem here. We have.
So does that go to there's a little bit of a back and forth in the papers about whether this is facial or as applied.
That's right. There is some of that, and it's both. It's facial and as applied, and that's not only what we allege, but it's also there's elements of both facial and as applied arguments in this case, and the distinction is it's not really super helpful in this case, and let me explain why real briefly. In a facial taking claim, you allege that the enactment itself takes property. Okay. Well, at the time of the enactment, we didn't own the property, so it became it took our property, the existence of the ordinance took our property when we became subject to it, when we purchased, when we acquired a certain property. So it has elements of both facial and as applied, and I think that's why there's a little bit of confusion there. It's just not a tight fit there. And you could look to Cedar Point, which was supposedly a facial claim, but the court just resolved it as a takings claim because it was a regulation, like here,
What about the
that applied
fact
to a problem.
that in your complaint, every count, except for your due process counts, you say in parentheses, facial?
There is that in there, and that's
So
part-
if you're the court, certainly if you're the district court judge, and you get that, and it says facial, how are we supposed to say, well, no, that's not just facial, it's as applied, and put on top of that the broad remedy that you're seeking?
Right, and I understand that point, but the district court did not resolve it as a facial claim. And I'd just like to point out for the record, Salerno, every application has never been applied to a takings claim. It doesn't apply to the takings clause. This court has never applied Salerno to a takings clause. The standard is in Keystone Bituminous Coal Association, the standard for a facial takings, if you were to conclude that this is only a facial takings, the standard is whether the enactment of the regulation itself takes private property. And so even if that is the standard and all our claims and all the argument is only facial, which I dispute, we would still, the analysis is still the same, and it would be something like this. The existence of this ordinance causes a per se physical taking of BBLI's property. It's not necessarily how the city is going to enforce it with each tenant, or this operates in every instance with BBLI's property to take its property without just compensation or public use.
Okay, we used a lot of your time with questions, and I know you wanted to reserve 2 minutes, so how about we give you that, and in the meantime, let's hear from the city.
Thank you.
You're welcome.
May it please the court. When tenant-occupied residential properties go through foreclosure, the impact on families and communities are very destabilizing. To help address this issue, the city passed the Keep Chicago Renting Ordinance, which regulates the landlord-tenant relationship in the foreclosure context by requiring new owners to do a lot of different things, including registering the property with the Commissioner of Housing, ascertaining identities of occupants, providing written notices, negotiating new rental agreements in good faith, and only in the contingency where new rental agreements are not reached, provide relocation assistance. Plaintiff claims that this portion of the law violates the takings clause, primarily calling it a physical per se takings, but analyze under any approach, it's a valid regulation of the landlord-tenant relationship that does not violate the Constitution. Just a level set here on the physical per se taking claim, the Supreme Court has explicitly held that statutes regulating the economic relations of landlords and tenants are not per se takings, absent the government's physical occupation of the residential property. BBLI attempts to create the appearance of a physical taking claim where none exists by ignoring that broad power and focusing on the mere transfer of money in the ordinance in isolation. But the Supreme Court has recognized that governments may require landlords, as part of entering into this relationship, to provide for things of value toward their tenants' benefits. This could be utility connections, mailboxes, building-wide sprinkler systems, etc. Providing relocation assistance can just be easily added to that list of things. Now, plaintiff argues in their reply brief that some of these other things of value either serve different purposes or can be less expensive, but none of that matters for the physical per se takings analysis, where the hypothetical taking of something worth 1 penny is the same as something taking very expensive or valuable.
What about the fact that there are no requirements on what they spend this money on? And how does that impact the public use piece?
Well, the city's position is that that would only maybe go to the public use requirement, but that the public use requirement isn't relevant to this case, because either it is not a takings and then we don't have to get to public use, or it is a takings and we don't compensate, so it doesn't really matter whether there's a public use or not, like win or lose, there's still no compensation. So the public use analysis never comes into play into this case, but...
Hold on, slow down just a second and go over that one more time.
So either the law is not a takings, as we contend.
On the per se point.
Yeah, or on any point, whether regulatory or per se, it's not a takings under whether it's potential analysis or per se analysis, and then we don't get, it doesn't matter what the public use is, because it's not takings at the outset, we're not even operating in the takings clause. Or it is a takings, and then we're not compensating them. So even if we win the point that it's a public use, the law's still not valid. So there's no scenario where you get to, in this scenario, we get to the public use requirement. Public use requirement is for, we take something, we provide compensation, and they say you still couldn't do that because it wasn't for a public use.
Suppose, for example, that the district court did not rule in your favor on the motion to dismiss, and the case proceeded to discovery. I think you would quickly agree you wouldn't have an interlocutory appeal. There's no finality. I can't imagine that there would have been a certified issue or anything like that. It would have proceeded to discovery.
Okay.
Okay. And suppose that the discovery showed that 95% of the recipients of payments under the ordinance said that they took the payment because they viewed it as an incentive to move. Alternatively, suppose that 95% of the recipients said they used the money for non-housing purposes, for other personal purposes. Okay. Is any of that relevant? Would any of that be relevant in summary judgment briefing on the plaintiff's claim? If so, how? If not, why not?
No, it would not be in our opinion, because it doesn't matter for the physical per se, which is looking at the nature of the taking itself. It's
How about on the regulatory
on the
takings?
regulatory, under the 3 Penn Central factor in discussion, I don't see how that comes into play on any of those, because we're looking at the economic impact on the landlord. We're looking at whether they their investment-backed expectations. What they're concerned about is that they lost the money in this regulation, not what happens to the money after it's lost. Maybe that could come into play in a public use style analysis, but again, we're arguing that the public use isn't dispositive for this
Is
case.
the dollar amount of the payment set under the ordinance relevant or irrelevant?
It's relevant for the Penn Central analysis. It's not relevant for a per se takings analysis. So if we're looking at the economic impact of the Penn Central regulatory, you can imagine a scenario where, and then that's into very fact-dependent things, which gets to the whole issue of facial versus as applied here. But let's say they bought a property for $10,000 and the regulation makes them spend millions of dollars on some relocation assistance. Maybe the economic impact factor would be at least in their favor in that situation. But so it factors into the multifaceted Penn Central analysis, but it's not relevant for per se. Now, to be sure, money itself can be a form of property protected under the takings clause, but only when there's a vested monetary interest that's taken, not just the mere general obligation to pay on the happening of a contingency, which is all we're dealing with here. I mean, if you look at the Supreme Court's decision in Eastern Enterprises, notwithstanding the split opinions, all 9 justices agreed that the regulatory obligation to generally pay money was not a per se takings. Then they went on to dispute whether it was a regulatory takings under Penn Central. And then if you look at the Supreme Court cases since Eastern Enterprises, they've held that money is a per se takings only when a specific source or pot is kind of physically taken. For example, in Brown v. Legal Foundation of Washington, it was the interest earned on lawyer trust account that the government went in and took that money.
What is the weakness in BBLI's argument that obviously when I am an investment owner, I buy a new property, I've got money that I want to use to either improve the property or take the property in a different direction, et cetera, et cetera. So if you're requiring me to pay $10,000 per tenant who chooses to leave, that was money set aside for a different source. What's the weakness there?
Well, I still don't see how that plays into the per se physical taking claim, which is looking kind of like the nature of what the government's doing here. There was some discussion in the opening arguments about like what would be the limiting principle here. I think that's important for this discussion because any regulation operating upon a property owner for owning property would be under their rationale something that would be per se, not just potentially to owners under Penn Central, but per se a regulatory taking. That's completely untenable. I mean, if you think about requirements for landlords to make repairs or maintain habitability standards, that would be a required monetary expense that operated on their property interest. Or another example from our brief, car liability insurance mandates require the owner of cars to pay money to private insurance companies to register or operate their vehicle. That expense, under plaintiff's reasoning, would operate upon a property interest. These sort of regulations where simply money is required to be expended in certain situations have never been analyzed as per se takings. Again, regulations can theoretically go too far, be too onerous under the Penn Central analysis and become a takings, but that's an entirely separate inquiry from whether there's a physical per se takings of money. The plaintiff relies heavily on the Kuntz case for their per se takings analysis, which was an unconstitutional conditions case, not a per se takings case. And it held that the government cannot circumvent the limits on coercing a property owner to cede certain real property by offering them the alternative of forfeiting money. The Supreme Court explained that in such a context, the monetary payment was the functional equivalent of the prohibited exaction of physical property. But here there is no physical exaction for which the money is in lieu of. Instead of taking an equivalent in the interest of the real property itself, the city is merely regulating a landlord's obligations to its tenants when that relationship comes to an end. Simply put, the plaintiff's entire attempt to cast this as a per se takings claim is a misdirection. Instead, the ordinance is properly analyzed under Penn Central, which is economic impact, investment-backed expectations, the nature of the government action, each of which indicates that the relocation assistance is not a taking. For the economic impact factor,
Why isn't that a factual question that should proceed to discovery?
The
Penn Central
factor?
analysis.
Well, I mean, this also gets into, no, it does not, because to the extent we are correct and all they have pled is a facial claim, they need to prove the law is, not constitutional in any of its applications. So here, when they were talking about, well, if the tenant chooses to leave, being opposed to being forced out by the landlord, or if they don't use the money for certain factors, that's all may be relevant for an as-applied challenge, but not relevant for a facial one. And then here, even if you give them the opportunity to plead an as-applied challenge on this, well, they haven't alleged any of these economic factors. So even based on the pleadings, they've still lost. Because
Do they need to plead Penn Central, though?
so I would say
Under
that
Rule 8 and our requirements that you plead?
I would say it's a little unclear whether they are required to legally plead, we are pleading a regulatory takings claim versus a per se takings claim. But there still needs to be enough facts in the complaint to support whatever type of theory it is that they're alleging. Obviously, those can be proved later during discovery, but regardless of whether it's unconstitutional claims, Lucas style, total regulatory taking claims, whatever the legal theory is for the taking claims, there still needs to be facts in the complaint to support whatever that legal theory might be. And here they have none of them.
How many facts do they need? They said, we bought it, we have these tenants, we negotiated in good faith. Some tenants didn't take the deal, they've left. And indeed, we see the lawsuit, the
Right,
class
well-
action lawsuit by the tenants. So what additional fact? Oh, and they said, this is going to be a lot of money for us.
Well, yeah, so, I think we're, in talking about the Penn Central analysis, what else do they need to plead? What I would say is they need to plead almost like the denominator of the equation. $10,000 of added expense on a $1 billion investment doesn't really even on the pleading show that they've suffered a significant economic harm. But maybe $10,000 on a $10,000 investment would be enough to plead that there's been a significant economic harm. So they haven't showed that the amount of the relocation assistance that we don't even know how many tenants they've paid out to. Based on the pleadings, there's 3 or so examples. Well, if their building is worth $1 billion, which we don't know because they didn't plead it, then so they have to pay $30,000 on a $1 billion investment. That's enough to even plead a significant economic impact. I wouldn't think so as an as-applied challenge. But again, we believe that they're primarily pleading a facial challenge, which, as opposing counsel recognized, is looking at the very enactment of the statute.
In other words, you agree that the Supreme Court, anyway, has not applied Salerno to takings?
I think it's a distinction without a difference, because what you're looking at in the very enactment is that applied to everybody that would be affected. The mere enactment that it's so eviscerated, so caused such widespread economic harm that it doesn't matter the as-applied facts, it would be facially unconstitutional. So I think it's different wording to describe essentially the same underlying principle for a facial claim. But here, the ordinance's impact is highly variable, placed on property-specific circumstances, how many tenants are in the building, and therefore how many they potentially need to pay out, the total value of the building and their investment, how many tenants may or may not sign a new lease. Imagine a scenario where every tenant signed a new lease. Then there would be no money that they would have to pay under a facial takings analysis. So the economic impact of these payments in relative to the underlying property are all case-specific, fact-dependent inquiries not presented here. The investment-backed expectations factor also runs squarely against their taking claim. As Your Honors noticed, they acquired this property years after its enactment. Therefore, they should have been on notice of possibly paying out these monetary relocation fees. And indeed, it's reasonable to assume that such a potential liability may get factored into the cost of acquiring such tenant-occupied buildings, maybe making them cheaper than they otherwise would have been. In the reply brief, they rely on the Palazzolo case to argue that this factor is inconsequential, but that is a complete misrepresentation of that case. In Palazzolo, the Supreme Court said that the acquisition after the effective date did not categorically bar a regulatory takings claim, and it remanded the case for actual consideration of the Penn Central factors. But we aren't arguing that their takings claim is categorically barred. We're just saying that the investment-backed expectations factor weighs against them on the merits.
What's your reaction to Mr. Bremer's point that, Ballinger, there's a lot of similarities with Ballinger, but there is a pretty key difference there with respect to the choice that the Ballingers made to not renew the lease and to evict the tenant?
We don't believe that distinction is dispositive in this case. Here, the relevant choice that's being made is by the incoming property owner voluntarily entering into the tenant-landlord relationship and therefore assuming the whole plethora of responsibilities that landlords have under current regulations.
I think he would say to you, that's not the choice, though, that is triggering the taking, or at least the alleged taking. The choice that's triggering the taking is the choice that's made by the tenant. In other words, it's not made by the fact that Edison bought the North Sheridan property doesn't, in and of itself require payments to tenants. The payments to the tenants come when the tenants ask for or choose to receive the payments. I think that's his point.
Right, and that may get into kind of the daylight between an as-applied and a facial challenge, because again, there's many scenarios where maybe the landlord wouldn't even offer a reasonable lease terms and therefore essentially forcing the individuals out. So that in that kind of scenario that could play out, the landlord is basically making the decision for the tenant in that scenario. So again, you wouldn't get into kind of the all of its applications type deal there. Again, even if you're looking at that choice, we don't believe that's dispositive for it. I think that goes back to the per se takings claim, because we still don't see how that operates upon an identified property interest any more than any other sort of regulation that forces landlords to do certain things. Whether it's, it could be providing things that are inexpensive, like smoke detectors, but again, the monetary amount in a per se taking claim doesn't matter. It is well established that governments can force landlords to spend money for their tenants' benefit. I mean, imagine if this case was a law saying you have to provide moving trucks. So it's not a cash value, but it's just another responsibility. Would that change the analysis? We don't think so. Either way, you're forcing a landlord to provide things of value for their tenants' benefit, which have not been held to be per se takings.
Okay, hearing no further questions, thank you very much. Appreciate it. Okay, Mr. Bremer.
Thank you. I'll try and quickly address each particularly regulatory concern that Your Honors raised to opposing counsel. First, as far as what you need to plead, again, look at Yee versus City of Escondido. There's a footnote in there where the Supreme Court says you just need to plead a takings claim, and the theory that you use can change while you're going through litigation. You don't have to explain your whole theory. Secondly, as far as Judge Scudder, your questions about what on Discover we would find out whether 95% are spending it for this or 95% are not spending for this, that would flesh out the economic impact. That would flesh out what the cost is of this requirement for BBLI, because we would find out who's spending it, what they're spending on. So we would also know the cost. We would know more about the cost, and that would go to economic impact. We'd also learn about the expectations about the as counsel brought up several times, about what are the expectations when they bought this property, if that matters again, and the character of the government action, that would go to the character, whether this actually moves towards serving a public use is more of a private benefit where the public use is incidental. And if it's an incidental public benefit, then the character would also point towards a taking under the Penn Central analysis. So it's important that it is a factual, holistic sort of determination that does generally require some discovery. And I think, as Your Honor mentioned, we have pled enough for that. We've pled $2 million loss from this. You can see from the class action that it could go more than that. But we pled a severe economic impact, and we pled the character of the action. There's no public use. It's like a physical invasion because they're appropriate.
Do you agree on the public use? Do you agree with Mr. Merrill that we don't even need to get to that element if we find no taking up front?
If there's no taking, then you don't get the public use. But I would say the flip side of that is if there is a regulatory takings question here, or per se that needs to go down, then the public use claim needs to go down with it, because that would be tied to that. And I'd also, as a question to Judge Scudder about the public use comes before compensation, both in the text of the takings clause and in general. If there's no public use, no amount of compensation, it doesn't even matter. So if the taking is tied to the public use, they go together, and then we would have discovery to figure that out.
The class action, is it on pause until this appeal is resolved, even though it's a separate case, or not?
It is on pause right now. Nothing's happening to that. I think there's a discussion and mediation coming up, but it's not in active litigation at this time. A motion to dismiss was denied. That's about it.
But is the pause related to the pendency of this appeal?
I don't think there's a formal order along those lines. No, Your Honor.
Okay. Mr. Bremer, thank you very much to your colleague as well, to the city. Very much appreciate the advocacy this morning. We'll take the appeal under advisement.
Thank you, Your Honor.
Our third argument of the morning is in appeal number 25-1638, American Art Clay Company versus Cincinnati Insurance. Okay, Mr. Morgan, good morning. Hold on one second. Okay, whenever you're ready.
Thank you, Judge Scudder, and may it please the court. This appeal is about a contract dispute. And like all contract disputes, it turns on the language the parties actually agreed to. Everyone agrees that the underlying bodily injury lawsuits here trigger American Art's insurance coverage, and that means Cincinnati must defend those claims unless some policy exclusion clearly and unmistakably takes that defense away. And so the appeal turns on what those policy exclusions say. And I'd like to begin with what American Art thinks ought to be its baseline. And that's a defense under the various policies bearing the 1996 exclusion language. The question, when we look at that short exclusion, is whether it clearly and unmistakably says that American Art will lose its insurance anytime someone falsely accuses it of having asbestos in its products.
Can I ask you a clarification question? What is the 1993, what is the role of the 1993 policy in this case? Is it here merely as a vehicle for American Art to argue how we should construe the relevant policy, which is the 1996 policy? Or is the 1993 policy somehow governing some of the underlying lawsuits? Some of the clay was sold underneath the 1993 policy during that time period. Which one?
Yeah, Judge, it's the latter. There are certain claims that would be subject to the 93 exclusion language under various policies, and then certain other claims that would be subject to the exclusion language from 1996.
Okay, thanks.
And so the question is, does that, starting with the 96 exclusion, does it clearly and unmistakably say they lose their insurance anytime someone falsely accuses them of having asbestos in their clay, even when the real-world facts confirm that they don't? To be sure, insurance companies write those sorts of exclusions all the time. They write exclusions that are triggered by actual or alleged asbestos exposures or claimed asbestos exposures, or as in Ebert, a particular type of injury for which the insured may be held liable. Cincinnati didn't do any of that here. Instead, it drafted language that most naturally read applies only to actual asbestos exposures. At a minimum, even if that's not the most natural reading, it is one reasonable, permissible reading of the 96 exclusion, and of course, any ambiguity must be construed in American Art's favor. Now, for the most part, Cincinnati's brief doesn't want to talk about the actual language of the exclusions it wrote. It instead argues for what amounts to a one-size-fits-all policies common law rule that says courts may never look past the allegations in the lawsuit to the real-world facts, no matter what the party's contract says about that. But that argument has a real problem because it bumps up against the fundamental premise underlying the entirety of Indiana insurance law. And that's that insurance policies are contracts and courts will enforce the party's bargain. So whether allegations, mere false allegations, are enough to trigger an exclusion has to always turn on the actual exclusion language.
Why do you need the word false in there? Under your predominant argument, don't you win if you're just talking about allegations and forget the word false?
We do. That's correct.
Okay.
And the problem with this sort of common law rule that Cincinnati argues for is actually worse than just that it looks past the actual contract language. Consider this. It is undisputed under Indiana law in cases like Mallon and the Supreme Court's decision in Friedline and various other cases that when the allegations in a complaint clearly trigger coverage, the insurance company may always look beyond the allegations to the real-world facts and may always deny coverage if the real-world facts justify it. And so here's the world as Cincinnati sees it. Courts must always look beyond allegations to the real-world facts if it lets the insurance company deny coverage. But those very same courts may never look beyond allegations to the real-world facts if it would require the insurance company to honor its contract.
Can you talk a little bit about what seems very odd to me about your position is in all the duty to defend cases that we have across all kinds of states here, one key aspect of the eight corners rule and principles around the eight corners rule is that kind of at time zero or ex ante there can be real efficiency in a determination made on a duty to defend question. In here you're saying there's a duty to inquire, there's a duty to investigate, there's a duty to do more. And what is the more that you believe they should have done? You're going to say, in part, I think, well, we have a letter from the Duke Medical School, and we'll show them the letter from Duke Medical School. But Cincinnati Insurance is going to say, well, you still have plaintiffs in court bringing tort claims alleging asbestos exposure. So maybe your Duke Medical letter will mean that you win the tort litigation, that the plaintiff loses the tort litigation. I just don't understand what the content or what this whole duty to inquire is going to even entail. What's that going to look like on the ground?
Well, the duty, I think their duty to inquire is primarily, I think, related to the bad faith claim. To be clear, what we're really talking about is their duty to defend unless and until an exclusion is triggered. And so what we have here is we have bodily injury claims, and everyone agrees. Those
but no, hold on. They're saying, how can the exclusion not be triggered? All the tort litigation is alleging that asbestos caused bodily injury.
Because the exclusion doesn't say that mere allegations of an asbestos injury will take away their insurance.
So that's why you say in your brief, right? I get that, but that's why you say in the brief. So there's some kind of, you can pick the term. I'm not hung up on the term at all. There's some kind of duty to investigate. They have to do more than just look at what's alleged in the tort litigation.
On the bad faith claim, yes, but on the claim up on appeal is the contract claim. I think even if they had determined in the first instance that they don't think they have to cover, we might still have a breach of contract claim. We would say, well, wait a minute.
So no aspect of your duty to defend claim, the contractual duty to defend claim, no aspect of it entails some kind of contention that they have to investigate or inquire or do something beyond the 8 corners rule?
It certainly does, that they have to look beyond that. But the point is,
What does that looking beyond entail?
yeah, I mean, here, and you referenced this earlier, here I think it would have been as simple as turning to their decades-long customer and asking 2 questions. Does your clay have asbestos in it, and has it been tested? And if they'd asked those 2 questions, they would have gotten the Vanderbilt testing, they would have gotten the Duke University testing, all of which shows that there's no asbestos in these products. So the question here really comes down to, what's the contract say, right? So in the first instance, it's a bodily injury claim. That means that it's covered. Everyone agrees it's covered on the coverage question. And that means we have a right to a defense. The only way that defense gets taken away is if some exclusion clearly and unmistakably says, yeah, but if someone alleges that there's asbestos in your claim, you lose your coverage. And think of this kind of a simple example. Imagine a car owner who, like most car owners, has auto insurance. And like most policies, there's an exclusion for drunk driving. If that car owner is driving home from church one Sunday afternoon completely sober and gets into a fender bender, and a few months later gets sued, and the other driver in that lawsuit accuses them of being a drunk driver, no reasonable policyholder in their right mind would ever dream that they would have lost their insurance coverage for that lawsuit, unless the exclusion clearly and unmistakably says that mere allegations are enough. And again, we see those sorts of exclusions all the time. Insurance companies write them all the time. So whatever sort of practical difficulties that Cincinnati might have.
But it seems like you're saying that they have to get into the merits before making a duty to defend determination, which would mean the client, the insured, could always say, well, those allegations are false, and you have to defend me because they've said there's asbestos in here, but there isn't.
And this, I mean, I think this court took that issue head on in Hayes Limmers. The insured is entitled to a defense against even meritless claims. That's not that's an accepted principle of Indiana insurance law. And so,
but in the law, the Indiana insurance law, it says you have to look at the nature of the claim, not the merits. That's separate.
And the nature of the claim here is a bodily injury claim. So that's a coverage question. The nature of the claim is that it's a bodily injury claim. It's covered. We're entitled to a defense, unless an exclusion clearly and unmistakably takes that defense away. And an exclusion that says mere allegations of asbestos take it out of coverage, that would be enough. But we don't have that kind of exclusion here. Briefly, before I yield the rest of my time for rebuttal, I want to talk briefly about the 1993 exclusion, Judge Jackson-Akumi, that you asked about, because we acknowledge that they at least have a toehold under that language to argue that mere allegations are enough, because the word claims at least appears somewhere in that exclusion. But that toehold doesn't get them very far, because the key language in the 93 exclusion, the which arise out of, are attributable to, or are any way related to asbestos adjective phrase, modifies bodily injury and property damage. It doesn't modify the earlier noun claims. And so the most natural reading of the 93 exclusion, and the reading consistent with the nearest reasonable referent canon, is that a claim for bodily injury triggers the exclusion if it involves an actual asbestos exposure. And so here again, even if that's not the most natural reading, we would argue that's at least one permissible, reasonable reading of that language. And again, any ambiguity in the exclusion must be construed in American Art's favor. If there are no other questions at this time, I'll yield for rebuttal. Thank you.
Okay, very well. Mr. Morgan. Mr. Garish, good morning.
Good morning. Good morning. May it please the court, Jeff Garish on behalf of Cincinnati. This is really a single issue case. My friend has tried to parse it into a couple of sub-issues, but I think it's really mainly a single issue case, and the issue is whether claims for bodily injury caused by asbestos are potentially covered under the party's insurance contract, which specifically excludes bodily injury arising out of, attributable to, or in any way related to asbestos in any form or transmitted in any manner. It is a very broad asbestos exclusion that applies plainly to preclude coverage. Judge Pratt got it exactly right, and that's why we think the court should affirm. Their main argument is that the exclusion doesn't apply because their products don't contain asbestos. The problem is it is, as Judge St. Eve, you correctly noted, it's the nature of the claim that determines coverage, not its merits. That is the case, I think, in probably all 50 states. It's certainly the case in Indiana, because the Indiana Supreme Court has specifically said so in the Kopko decision, and they've argued very strenuously in their brief that Kopko is no longer the standard, and yet the Indiana Supreme Court once again reiterated that standard in 2022 in the Ebert opinion. That remains the standard. It's the nature of the cause of action, not the merits of it, that determines whether coverage exists. And
It seems like under Indiana law that the courts have been inconsistent on how they've applied Kopko, but they've been inconsistent on what you can look at up front rather than just the four corners of the underlying complaint, that maybe you can look at other things, but they haven't been inconsistent on the nature versus merits piece.
Exactly right, Judge. Exactly. And the Stroh decision from this court talked about various articulations. They've articulated it in different ways, but they've never retracted or moved away from the fact it has to be that the nature of the cause of action determines coverage. And here's the thing, and this goes to Judge Scudder, your questions. Even there is, I will stipulate, there's some case law that says an insurer may look behind the allegations, but it doesn't get him anywhere. That's the problem. Their argument is we needed to look behind the allegations and find out that their products actually don't contain asbestos. He said it today. It doesn't help them because the nature of the claim is still bodily injury caused by asbestos. That's why it's not covered.
Can I ask you, you do this for a living, and you'll know the answer to this, and Mr. Morgan can weigh in on it too. Suppose as a practical matter, you just chose to defend. Cincinnati just made a choice, we'll defend. But we're going to defend with a reservation of rights. And the reservation of rights is there because as we read the underlying tort complaints, or as we construe them, these cases are all about asbestos causing bodily injury. We'll defend you, okay? And then it turns out that that's exactly what the trials are about, as you would expect. And whether American Art wins or loses the trials that way, could you, at the end of all of that defense, could you seek contribution for the fees on the ground that we defended you on claims that were all about an exclusion in the policy?
I don't know that there's any term in the insurance. It's a harder question than you think. I might do this for a living, but I'm not sure I know the answer. I think it depends on what's in the contract. I don't think there's anything in the insurance contract that talks about contribution of defense fees expended. I think the parties could agree to something that up front before defense was proffered.
Oh, okay. So if it's in your view, it's a contractual question entirely?
I think so.
Okay.
I think so. And here, aside from their main argument, their fallback argument has been that there's an ambiguity in this exclusion. And Judge Pratt, I think, got it exactly right when she said that the mere fact that ambiguities are construed in favor of the insured doesn't mean what they're doing here is they're trying to invite judicial construction by creating ambiguities that don't exist. I think that's exactly right.
Why shouldn't we look at the change in the language between 1993 and 1996 if our chief goal is to kind of divine the intent of the parties in contracting? The word claim was explicitly taken out. Should we ignore that?
I don't think you need to ignore it, but I would say there's more than one way to write an exclusion. And I think with judicial decisions that are constantly telling insurers to use plain language, it makes perfect sense that insurers would alter their language at times. But the problem they have, the 96 exclusion doesn't help them. The fact that the word claims isn't in there doesn't make any difference because it still excludes coverage for bodily injury or property damage arising out of, attributable to, or any way related to asbestos in any form or transmitted.
Well,
it's the only way they can be held liable. That's the problem.
That's if the 96 is read as you suggest.
Well, I just read it literally, though.
The in 1993, American Art was explicitly told, even if somebody accuses you of having asbestos in your product, we are not going to cover that. That's what the word claim is doing there. In 1996, if American Art is sitting and watching the changes in its policy, they have been involved in these discussions, that explicit warning is not there anymore. So
Well,
why shouldn't we credit their argument?
because the language wasn't changed in a way that makes any difference. It doesn't make any difference that the word claims isn't there. And I can prove this by citing the Indiana Supreme Court decision Ebert, which my colleague mentioned today. Ebert involved the exact same approach as the 96 exclusion. Here's the exclusion in Ebert. Ebert involved an exclusion, and it was a liquor liability exclusion. And the exclusion said, and I'm quoting now, this insurance does not apply to, and liquor liability, it was the heading of the exclusion. And then it said, bodily injury or property damage for which any insured may be held liable by reason of causing or contributing to the intoxication of any person. It didn't use the word claims, it didn't use alleged, it used the exact same approach as the 96 exclusion. And the Indiana Supreme Court unanimously held there's no duty to defend based on that exclusion because the claims were for damages that are governed by that exclusion. It's the exact same approach. And that's why they lose. That is completely fatal to their argument about the 1996 policy. And
Can you spend a minute on what do you understand the duty to inquire, the duty to investigate, the duty to take a look? Phrase it how you prefer. What do you view it to entail, at least as American Art would have it?
Well, I think it entails a look behind the allegations to find out what's really going on at times. Depends on the allegations, the underlying complaint.
So if they sent you a letter from the Duke Medical School, you'd either have to accept it on its face or hire a scientist to undertake a chemical evaluation of the talc?
Yeah,
all of that just seems very counter to what many states talk about with a duty to defend being made upfront, 8 corners, efficiency, ambiguities, all that kind of stuff. This whole notion of like we're going to have a scientific investigation or something. Or maybe their point is that you're duty bound to just accept the Duke Medical School letter. I don't know.
Maybe I don't either, but I think your instinct, Judge Scudder, is exactly right. There's no duty on the part of the insurer to accept anything that they say, especially from an expert or something that talks about what's really going on. But again, it doesn't matter here because even if you assume there's no asbestos in their products, it does nothing to change the nature of the claim. The nature of the claim is still bodily injury caused by asbestos. And if there is no asbestos in their products, they are going to win the underlying claim, but that doesn't have anything to do with the coverage, which is the nature of the underlying claim. And that's, again, exactly what Kopko said. Kopko even talked about, late in the opinion, it talked about the defense that the insured had, that they forgot something. There was a slam dunk defense that they were going to win the underlying lawsuit. And Kopko said, okay, you might win, but it doesn't matter because it doesn't change the nature of the lawsuit, which is not covered under the language of the policy. Now
is there I might be reading too much between the lines, and maybe Mr. Morgan is going to want to comment on this, but I read this as they're frustrated, and they're frustrated because they find themselves named in a bunch of tort cases where there are manufacturers of attic insulation and building material manufacturers, and here American Art that manufactures a clay product for home artistic recreational purposes is alleged to have asbestos in it, and so they say we're just swept up in this and we're brought along for the ride, and that's costly, but these claims are really against people that manufacture insurance, insulation, and building products and all that. And that's why you all at Cincinnati Insurance need to step up and defend us in this, because it's bogus. It's ridiculous.
Well,
there's a flavor of that between the lines of these briefs. Is my mistaken on that?
No, I'm sure they are frustrated that they were sued on baseless allegations that they have asbestos in their
Because the
products that they
lawsuits
really
are
don't.
not, Jane or John Doe versus American Art. It's all these other, where you traditionally will see tort litigation, asbestos litigation.
Right, and they were, again, I can understand where they're frustrated being sued for something they claim is a baseless allegation, but again, their insurance contract that they agreed to contains asbestos exclusions that exclude coverage which arise out of, are attributable to, or are in any way related to asbestos in any form or which may be transmitted in any manner. That's as broad as it gets. I mean, I have seen asbestos exclusions. They are narrower, where there might be a basis for finding an ambiguity as to whether this form of asbestos qualifies, but there's no wiggle room here. And they didn't have to agree to this language, but they agreed to it. And that's the problem. They agreed to an asbestos exclusion that governs these lawsuits, and as Judge Pratt correctly held. Now, they do also argue the 93 exclusion, and he mentioned it again today. And I would respectfully submit this is a good indication of how hard they're trying to find an ambiguity that doesn't exist. Because in the trial court, they argued as to the 93 exclusion that there was a missing closing comma, and Judge Pratt rejected that argument. Now they've abandoned that. Now they've got a completely new argument based on the nearest reasonable reference canon, and they're saying that claims only applies to bodily injury or property damage. So they would read the exclusion. They say the only way the 93 exclusion could have applied is if they had drafted it to say this, and this is right on page 24 of their brief. They say the exclusion had to say, this insurance does not apply to claims for bodily injury or property damage which are claimed to arise out of, claimed to be attributable to, or are claimed to be in any way related to asbestos. Look, you can always make any language more redundant. I mean, I think any clause could be more redundant if you wanted to, but that doesn't make the language as used in the 93 exclusion ambiguous. And Judge Pratt got that exactly right. There's no ambiguity in the language. And then their last argument as to ambiguity is that the term asbestos, the exclusion doesn't necessarily apply because of the form of the asbestos. And this is to your question, Judge Scudder. But again, the exclusion says in any form or which may be transmitted in any manner. So it doesn't matter if the type of asbestos that's alleged to be in their product is a different form than what other defendants involved. It just doesn't make any difference. So I'll be happy to answer any questions if the court has some, but I don't think I need to use the rest of my time unless there are questions.
Okay, hearing none. Mr. Garris, thank you. Yeah, Mr. Morgan.
Thank you, Judge
Mr. Morgan, or is your client prevailing on these underlying lawsuits?
We don't have in the record any answer to that question. I actually don't know that how far along any of them are of the 58 that are at issue here. But I want to talk about two things on rebuttal. The first is this idea about the nature of the claim. It's absolutely right that the case law talks about the nature of the claim, but that's the coverage question in the first instance. Once you establish coverage, the burden shifts to the insurer to say, okay, but this exclusion clearly and unmistakably takes your right to a defense away. Here we have a right to a defense if we have coverage. And so we're here in the exclusion context where they have to prove their affirmative defense that an exclusion applies. So I want to make sure that we're not losing sight of the nature of the claim here is a bodily injury claim, and that triggers coverage in the first instance. Everyone agrees about that, including the district court judge. The second thing I want to talk about is this idea that there is an 8 corners rule in Indiana. And their argument, the latest word from this court in Hayes-Limmers is that there's not, that COPCO actually never stood for an 8 corners rule in the first place. That's what this court concluded in Hayes-Limmers, and that's of course consistent with the Indiana Supreme Court's decision in Harvey, which clearly looks beyond the allegations to the real world facts. And it wasn't that it just forgot about COPCO, we know, because the Supreme Court cites COPCO in the Harvey case. Their response is to talk about the Ebert case from 2022, but there are 3 reasons why Ebert doesn't supply the answer here. First, the Supreme Court tells us in the first two paragraphs of that case that what it was really deciding is this efficient and predominant cause question that had split Indiana courts in the liquor exclusion context. And we think we should take the Supreme Court at its word. We certainly think there's no good reason to think that what the Supreme Court was actually doing in Ebert was silently overruling its own unanimous decision in Harvey, silently overruling Court of Appeals decisions like Selective Insurance, North Vernon, Drop Forge, and Monroe Guarantee, silently abrogating this court's decision in Hayes Limmers, and scores of district court cases, all squarely rejecting the Eight Corners rule under Indiana law. And that it was doing all of that without so much as even acknowledging that that body of law exists, much less discussing it or explaining why it disagreed with it. And the second reason we don't think Ebert supplies the answer here is even if you thought the Supreme Court was silently doing all of that in Ebert, it would then make no sense for a Supreme Court that just said courts can't look beyond allegations to the underlying or to the real world facts, to then in the very next paragraph of its opinion look beyond the allegations to the real world facts. And that's exactly what Ebert does on the scope of employment question. And that takes me to the third reason why Ebert doesn't supply the answer here. Because Ebert, like every insurance coverage decision, must be understood in the context of the actual contract language in front of the court. And there, Ebert, and Cincinnati spoke about this, the Ebert policy excluded particular types of injuries for which the insured may be held liable. That's the sort of exclusion triggered by mere allegations. For example, if our policy had that language, as we stand here today, we may be held liable. For all of our system's virtues, fact finders sometimes get it wrong. We may be held liable. And so if they had that sort of exclusion language here, they're absolutely right it would apply. But they don't have it. What they don't get to do is write the exclusion they wrote, collect premiums on it for decades, and then come to court decades later and say, let us out of the bargain we struck. So for all of those reasons, we would ask...
Before we let you go, can I ask you a question? Going back, you read Hayes Limmers, our 2010 opinion, pretty broadly. What language do you have in mind there that where we held that Indiana law has not adopted the Eight Corners rule?
Yeah, so first Judge Posner talks about how it's not at all clear that what the nature of the complaint means is just the allegations in the complaint. That could also mean the allegations in the complaint and the other information. Yeah. And then I think it's the bottom of that same paragraph, then the court goes on to look at the actual facts. The court goes beyond the Eight Corners in Hayes Limmers.
Okay, I see how you get there. All right, very well.
Thank you.
Okay. Yep, Mr. Morgan, thanks to you and your colleague. Mr. Garish, thanks to you. We appreciate the advocacy on both sides. We'll take the appeal under advisement. Our third argument of the morning is in appeal number 243110, Juan Mendez versus the City of Chicago. Frankel's here, right? Yeah. Good morning.
Good morning, Your Honors. May it please the Court. I'm Adam Frankel. I'm here on behalf of Mendez, plaintiff appellant. Thank you for allowing me a little additional time for this argument, and I believe it's warranted because this is a more significant case than it might appear. I know your dockets are full and excessive force cases come across your desks often, but this case is significant due to the timing of the issuance of two decisions. It was already important, but it was heightened by the timing of a couple decisions. The U.S. Supreme Court issued Barnes versus Felix in May while this appeal was pending, and this very court issued Pam versus the City of Evansville just at the end of September, and that dealt directly with an excessive force case. The video evidence was a prominent part of it, and the Scott exception was implicated and applied in that case, which is also, the district court in this case also did apply the Scott exception, and we strongly believe that it was misapplied. It's a very narrow exception.
Mr. Frankel, before you get into the merits, I just want to confirm, you are only appealing the summary judgment decision as to the excessive force claim, correct?
That's
Not
right.
the searches, okay.
Yes, Your Honor. We believe that we had many colorable claims, but in order to devote our resources properly, we had to focus on this, and because of its great importance. I realize that this is de novo review, and the court might be tempted to frame the issue such is the way, in the manner that defendants do fact-finding expedition and like the district court did. And that it has been said, this court has said that fact-finding is not an appellate court judge's province, and that would be inappropriate. I understand that the court needs to play a certain role, but I can't emphasize enough how important it is to frame the issue here as whether the district court performed its limited task properly in determining whether a genuine issue of material fact exists for trial. There's no reason that what the district court judge did should not have been performed by a jury. Above all,
As to the facts, Mr. Franco?
yes, Your Honor.
Are you disputing that the video evidence shows that Mr. Mendez had something in his hand? I know you're arguing it's not a gun, but are you disputing that that evidence shows he had something in his hand?
It is a contested material issue of fact that is in dispute, yes.
Okay, yep, my
Yes,
question was a
that's
little
right,
bit
yes.
different, so
Yes, Your Honor, we are disputing that.
you are disputing that the video depicts that he had something in his hand.
Yes, and whether he pointed it at the officers, which goes directly to whether the officer had a reasonable apprehension of serious harm. He was running away, and the district court observed in its recitation of the facts that he turned to look back over his shoulders to see where the officers were, and his arms swung in that direction. Mendez has consistently testified that the gun remained in his waistband the entire time, and the district court noted that there's nothing in the record to disturb that. And this implicates Pam because while the gun spilled out upon being shot, that is evidence where I believe the court in Pam may have overstepped or conflicted with this court's jurisprudence in using such evidence to support, to buttress this finding that it was a reasonable belief that Pam in that case presented. Because it's from hindsight, 2020 is not 2020, and it's the reasonable belief of the officer at the time. Subsequent events cannot be used to retroactively corroborate a reasonable belief because they weren't known at the time. It's a singular piece of evidence
Is it your position when the district court said, I looked at the video and I looked at the still images and I see something in Mr. Mendez's hand? Is it and you obviously dispute that.
Yes.
Is it your position that in making that factual finding, the district court was using hindsight? Is that what you're just now arguing?
I certainly believe that influenced his opinion and his interpretation of the video, but the video was subject and open to numerous interpretations. This court has opined at length about how videos are subject to varying interpretations. This is the role of the jury. The district court took it upon itself to perform that role, and because of its initial finding that it could not say, which we maintain is indistinguishable, his finding that it's not clear enough, it does not irrefutably reflect, we cannot irrefutably conclude that he was holding a gun or pointing a gun in his head, and that's what the court's ordered. There's no meaningful distinction between that and he was pointing something in his hand, and the court went on to kind of...
So do you agree that if the video does show that he had something in his hand and he turned back toward the officers, that your client loses?
No, Your Honor, I don't even think it's the place of the district court or this court to make that finding. I think it's a...
But that's a separate question.
Okay.
If that finding was properly made, do you agree that your client cannot prevail? That there was something, if the determination that the video shows, contrary to what your client testified to, that he had something, not a gun, but something in his hand, and as he turned back, he pointed it, whatever that something was, at the officers, that your client would lose.
I don't believe that the premise of.
I understand you
your que-
dispute the premise, but accept the premise.
It's the fact finding that's
But
the issue.
accept the premise. If that fact was accurately found, I think you have to agree under the law that your client would not prevail.
But why is that fact found by the district court judge and not a jury? What is the cost benefit here?
Again, I'm asking you to accept that. I know you don't want to
sorry, Your
accept
Honor.
the premise, but I'm asking you to accept the premise.
I will stipulate that if a jury made that finding, then yes, of course. But a district court judge is not in that position. This court has, with beautiful prose, resist the temptation, the siren song, the allure of fact finding of the district courts, especially in excessive force cases. These are inherently fact-driven cases. There's no reason for the court to have made this decision, submit this to a jury, but he chose to take it upon himself and the court just usurped the role of the jury, and that was a misappropriation and overstepping well-defined role of his. And the Scott exception is narrow, and it has a very high standard. It must be irrefutable where no one could find it. It could not be found interpreted in any other way. This court has said that video evidence, things are not always what they seem. People, based on inherent biases and different backgrounds, may see video evidence a different way. The trial is a necessary part of the adversarial process.
Mr.
And
Franco,
it
can I
allows-
ask you,
Yes, sir.
can we shift to a different?
Yes,
portion?
please.
And my question is this. So you've done a fine job, in my view, of articulating your point about the hand and that you can't see it. Okay. Do you agree, and maybe you don't, do you agree that the audio of the video picked up, you're going to have to help me on the, I think it's Officer Cook or Clark? Cook,
Yes.
okay. That it picked up Mr. Cook's audio during the brief chase. Do you agree with that?
I do, yes, Your Honor.
Okay, and do you agree that that's been kind of recounted accurately? In other words, there were 3 or 4 statements like waistband, waistband, waistband in his hand.
Yes, I do, Your Honor. But
Okay, what is the legal significance? Okay, if that fact is not in dispute, because at least that fact seems clear from the video. Set aside the hand thing.
Okay.
Okay. What's the legal? I'll give you time. Don't worry about the time. Okay. What's the legal significance in the Fourth Amendment reasonable force claim like this of those facts in kind of this, chasing in the scenario that played out?
Well, the shooting officer could simply rely on the fact that his partner yelled out waistband, waistband. He's got it in his hand to justify any use of force. But I really want to, I can't understate the importance of balancing the interests of the government. This court in Pam talked about there needs to be a forcible felony having committed to justify deadly force. He's running away. He's sitting on the porch with a youth and just talking when they approach. That's significant because it colors, and that's where Barnes comes in. Because it asks the court to expand the scope of the totality of circumstances inquiry. And under that inquiry, at the very beginning, he's placidly sitting on the porch. Why would he be a threat? And the shooting officer acknowledged that he's never had a suspect running away actually pose a realistic threat to him. The fact that Officer Cook yelled waistband, waistband is consistent with Mendez's testimony that it remained in his waistband and only fell out when he was shot. The fact that he saw it in his hand, maybe it could justify Scissor shooting him, but that doesn't. It's not. That's a very narrow. That is the approach the Fifth Circuit takes, that the U.S. Supreme Court explicitly rejected the moment of the 2 seconds before the shooting occurs. That's not what you're supposed to only include.
So your point, I don't want to put words in your mouth.
Yes.
You should modify and correct what I'm about to say. But your point is that when you look at the totality of this video and all, that there's enough ambiguity, enough uncertainty, that the best way to resolve this is to send it to a trial.
Absolutely.
That way, that's your point. When you add it all up,
Yes, sir, and I believe that Pam provides an excellent contrast. There, the officers knew. There was a telephone call to the police. There's a man trespassing in my yard. She described him. He fit the description. He pointed a gun at her. He pointed a gun at the dog. He was still trying to get into the house when the officers spent over a minute warning him. And then he turned to directly face them, and then the court could not determine whether he had a gun in his hand at the time of shooting or not. That is like this case, but it's completely different. In this case, at worst, Mendez would be guilty of unauthorized use of a weapon where no one was outside, and he was scared and he was running away. He was not facing them. The fact that he turned around and may or may not have his hand swung in that direction because of anatomy, these are all jury findings. I don't understand why the district court believes that that's its role, especially when it applied the Scott exception, which is a very narrow exception, and it only applies in certain circumstances where the evidence is irrefutable and entirely discredits the plaintiff's account of the events. And it didn't do that here. It simply didn't do that. That's why we believe the Scott exception was misapplied, and that Pam provides an excellent contrast to that.
You want to save some time?
Yes, thank you.
Yeah, very well. No problem. Okay, let's hear from the city.
May it please the court. The district court correctly granted summary judgment to defendants because the undisputed facts under the totality of the circumstances established that a reasonable officer would believe Mendez was pointing a gun at the officers, thereby justifying Officer Scher's use of deadly force. Summary judgment was also proper because, at a minimum, Officer Scher is entitled to qualified immunity, since it was not clearly established that his use of force was excessive. Finally, with respect to Mendez's battery claim, unless this court has further questions, we are prepared to rest on our brief. Starting with the Fourth Amendment excessive force claim. The Constitution permits a police officer to use deadly force when the officer reasonably believes, again, under the totality of the circumstances, that an individual poses a significant threat of death or serious bodily injury to himself or others. Here, the totality of circumstances gave Officer Scher such a reasonable belief. Those circumstances consisted of the following. He encountered Mendez while responding to an alert that a shot was fired in the vicinity just minutes earlier. Mendez and the minor were the only individuals in sight, so he reasonably presumed that they knew something about the shooting. Officer Scher instructed Mendez and the minor to stand so he could ensure neither was concealing a weapon. Mendez's refusal to do so raised Officer Scher's suspicion. Then, as he approached, Mendez jumped off the porch and fled. He pursued him, believing that this individual possessed, in some form, a gun. And as he did, he instructed him, and his partner instructed him to show his hands, and he continued to disregard. And as he did, he then heard his partner yell, "Waistband, waistband, waistband," which he interpreted as confirmation that a gun had been sighted. He then heard his partner yell, "He's got it in his hands," and moments later saw Mendez, again, turn back, look back, and point an object that he believed to be a gun based on all these circumstances leading up to this at him. And at that moment, he fired his gun to protect himself and his partner, and stopped once he saw the gun fall to the ground.
Can I interrupt? You just said point. I know that's the officer's position.
Mm-hmm.
I don't read the district court opinion as having made a finding that the officer pointed. I see the finding that Mendez had something in his hand. I see the finding that he turned, his right hand went up, either intentionally or inadvertently, impossible to tell. Where's the finding about pointing an object?
That's fair. I'm glad you corrected. It's more so that the interpretation, a reasonable interpretation, is it's a point, but the finding itself was arm raised in direction at officers, and the ambiguity there, I suppose, is the intention of Mendez. It's not ambiguous that we contend on our position that that's a reasonable belief. It was a point, but all of the physical movements are uncontested. And given that totality of the circumstances under this court's case law, Supreme Court case law, it was entirely reasonable for Officer Scher to use deadly force, and this court has affirmed as such as recently as Pam. It has also done so in a number of other cases, such as Johnson, Horton, and that robust case law speaks to also why qualified immunity is absolutely important here and warranted.
If we address qualified immunity on the clearly established prong, how would that impact the battery claim or the state law claims? Which were the
That's
court
a great
relinquished
point.
jurisdiction
Right.
over?
On the state law claims, it would not. It would also dispose of those because
On the clearly established, certainly on the first prong, the constitutional violation, but if we address only the second prong, clearly established, would that impact the battery?
the reason it would not is because of the State Tort Immunity Act. And so that raises the bar for officers that they must have been acting willful and wanton. And I would argue the clearly established then gets them over that bar. You're now not acting at that level.
Anything further?
If the court has no further questions, we ask that this court affirm summary judgment for defendants.
Okay, thank you, Ms. Chapman. Mr. Frankel, you do have some rebuttal time left. You're welcome to use it. Yep.
For this court to seize this opportunity to clarify and define the boundaries of the Scott exception. It's been spoken as a narrow, pragmatic exception that applies when there's no reasonable disagreement what it depicts, clear and irrefutable evidence, and it should not reject, the court should not reject a plaintiff's account when, just because the video offers some support for a governmental officer's version of events. Now, the court in this case, in its recitation of the facts, it noted that Mendez fell right before he was shot, was getting up, and he said, the district court said, this is not to say that Mendez intentionally swung or extended his right arm in the officer's direction. Mendez got up and continued to run, looking back over his right shoulder to see where the officers were. In doing so, his right hand and arm swung in the officer's direction. This is construing the video. Reasonable minds could differ on what this is being depicted here. Mendez's testimony lays the foundation consistently that this was not, but this is not the purview of the district court. And it overreached and it exploited the Scott exception by failing to use the inference in Mendez's favor. It refused to infer the facts in his favor. And discredited his entire testimony simply because he made finding a fact on his own and then discredited Mendez's testimony. In Pam, the court, pivotal to the court's ruling in Pam, was the fact that the plaintiff had died. He could not refute anything that the video showed. He could not offer his own version of events. And that was very crucial. And I believe that the contrast should inform between Pam in this case, should inform your decision because it's very stark on the facts of this case here. Can I answer any further questions?
Not hearing any questions. Mr. Frankel, many thanks to you.
Thank you, Your Honor.
Yep, done a fine job on behalf of your client. Thanks to the city as well, and we will take the appeal under advisement. Okay, our next argument of the morning is in appeal number 25-1293, Valley View Farms versus BOS Dairy and others. Yeah, Mr. Dahl, nice to see you. Hold on just 1 second. Okay, yep, whenever you're ready.
May it please the court. I believe we have 3 points on our side that we need to convince the court of in order to prevail. And admittedly, if we lose on any one of them, we're done. The first is that the harvesters' opinions of the tons per acre that they allege that they yielded, was that expert opinion or lay opinion? Second, if it was expert opinion, was it abuse of discretion to have that admitted before a jury? And 3, given that it was admitted before the jury, was that sufficiently prejudicial to warrant a new trial? And I believe on each of these, although we disagree in the briefing, the case law is clear as to what the standards are for each.
Mr. Dahl, your argument seems to have shifted a bit from your opening brief to your reply brief. So I want to make sure I understand what your argument on the expert testimony is. Are you arguing that the opinions here about what the acreage would yield are expert opinions and that's what they gave here? Or are you also challenging opinions on the tons per acre of corn silage to the extent that they individually harvested them? Do you understand the distinction?
I believe so. Each of the harvesters testified to how much they individually did.
And is it your argument that that testimony about what they individually did is expert testimony?
Absolutely. Yes, absolutely. And the reason being that it's not something either of us could do. Well, first of all, we couldn't drive a harvester. I suspect no one is here that could. And even if you could, you couldn't tell how much tons per acre you were getting based on the speed, based on looking at the corn, based on the weather, whatever conditions. I liken it to mowing a yard. I mean, we all know that we have to mow a little slower when the grass is higher, but we still couldn't say, well, that's, 5 gallons, that's 5 yards of grass or produce that number. Each of the witnesses was asked in classic textbook law school expert testimony, what's your background? How many thousands of acres have you done before? What did you observe that day? Reaching the ultimate conclusion. And we all learn, all trial lawyers learn that technique, and that is what was done with each one of them. I also confirmed, when my goose was cooked, with each one, is that specialized knowledge? Right? I couldn't do that, right? Each one of them admitted that. They admitted to their expertise.
Although we can't let the witnesses answer on specialized knowledge dictate whether or not it's really specialized knowledge.
I did get the magic word, but I first said I couldn't do that, correct? No one else could do what you do, and they each admitted it. And I submit...
Isn't that also true of lay witnesses who have particularized knowledge by virtue of their position? They can often do things that other people in the courtroom can't do.
Then I think that is when then it gets to where it's expert opinion rather than a lay opinion.
No, that's the definition of a lay witness.
And I'm sorry, Your Honor.
A lay witness can also have particularized knowledge by virtue of their position.
In certain circumstances, but not where the special expertise moves over into expert witnesses. And there's a very narrow line of cases. For example, business owners testifying about their profits and those kind of things. But lay opinion is limited to people's, someone's drunkenness or their emotional state or the speed of a car, something that we all can do in general. And what
do you think about I think the line drawing here is hard. It's what makes the appeal interesting. And what do you think about testimony where you go to somebody that's worked on cars for 30 years and they've replaced tens of thousands of brakes, and there's a personal injury because of a brake failure, and you call the mechanic in and you say, how many, I know the car owner declined to get the brakes or the rotors replaced. How many miles do you think those brakes had left in them?
I believe that's expert testimony without question. I couldn't answer that question.
No, I know. Well, no, but I think that goes to Judge Jackson-Kiwi's point that maybe you couldn't or I couldn't or she couldn't, but the folks that work on brakes, for 30 or 45 years possibly could that way.
I believe they could.
And that's not just based upon that is specialized knowledge in your view?
I believe it is, yes, Your Honor. And
what about a treating physician? What about a treating physician? We have said that when a patient goes to a treating physician and in the course of that treatment, the doctor, the physician, gives an opinion about what the cause of the injury was. As long as it's in the course of that treatment, that's lay testimony and that's permissible. How would you distinguish that from the harvesters?
I would distinguish that because these harvesters were specifically asked what their experience was as a build-up to providing the opinion. And I believe with the treating physician, if each one could do it, that conclusion is not based on their, it's not...
Certainly, I couldn't do that. You couldn't do that. It's certainly based on their specialized personal knowledge because they're doctors. And that's what they do. They treat these patients and sometimes when they're treating, they give an opinion or come up with an opinion about the cause.
Well, to fall under Rule 701, their testimony must not be based on specialized knowledge. So if there's special exceptions.
We have consistently said in the case law that that testimony is okay as lay opinion testimony. So I'm not sure how you would differentiate.
Well, then I would suggest then that if the courts have carved out exceptions in certain instances for specialized knowledge, harvesters of corn is not the next area to go to. It's not, you're probably never going to see another case like this. You will see others where there's other types of experts. And based on physicians or mechanics, I can see that coming up a lot. I can't see throwing away the distinction between Rule 701 and 702 because you have created exceptions in other areas.
Would you? Oh, go ahead. Go ahead.
I wasn't asking a question.
Oh, okay. I got another one for you, if you don't mind. All right, and that is, I have an impression of your case that you're going to strongly disagree with, but it's the benefit of your reaction that I'd like to hear. Okay, and that is, you spend a lot of time criticizing the three harvesters, okay, and you criticize them in part by saying this was really, really damaging to my case, okay. But your case didn't seem all that strong to me to begin with, okay, in that I totally understand the theory of it and the concern that animated the case, and completely willing to believe your client is convinced to an absolute certainty that there's been diversion of silage, okay? But you didn't have much direct evidence of that at all. In other words, you didn't have evidence that the scale tickets were fabricated, the scale guy was paid off. We got photographs of 3 or 4 truckloads going who knows where, but they weren't going to the the weigh station and all that. So all that is a way of saying any error here may well have been harmless.
Your Honor, admittedly, we had zero direct evidence of the diversion of the silage. What we had, our case was entirely built on our expert testimony. We had the foremost expert. First of all, we had the measurement made beforehand.
Yeah, that fellow that went out into the field, what's his name? Corning or something?
Mr. Corning, yes.
Okay, okay. That guy that went out into the field did a pretty limited sample, though, at least as I read the record.
Well, we had Dr. Lauer who came in and said that's the standard for providing measurements and providing an estimate of the tons per acre. The system that he used, take an 8.5-foot row of corn.
But how did Corning's work go to the issue of conversion versus the threshold question that you seem to be at, which is there's a difference between the appraisal we got and the yield. So this ties back to Judge Scudder's question about where's the evidence of conversion, and you mentioned Corning, but I don't see how that's circumstantial evidence of conversion.
It's evidence of how much corn was in that field compared to what was reported, but
they're not disputing that. There's a difference between the estimate and the yield.
And I believe with the additional expert testimony as to what the yield should have been based on the weather, based on pictures of corn we had from that time, based on the chemicals that were used, and based on the type of corn that was planted, that the number should have been higher. And it could have only been, it didn't disappear. It could have only, if the measure.
But did Corning help you make that particular point? If it could only have been theft at that point.
I believe so. It had to go somewhere. And the measurement and reporting of the corn was totally in the dairy's power. It was if someone gave you and I a bag of cash and I took it in the other room and I came back and I said, here's your half, it's $5. How would we verify that? And if we had all these other inputs on what that amount should have been that are inconsistent, I could have only taken the half that I should have provided to you. And I believe that was our case. And admittedly, there's no direct evidence. We didn't see someone driving off with the corn that we can name or get a picture of. But many cases are handled that way. And based on expert testimony. And we had the foremost expert to come in and say, these numbers, something smells here. And included testimony on how they could have done it. They could have a finger on the scale. They could not dry the corn all the way when it's measured. Any number of ways. And a jury is entitled to rely on that, and that's where the determination should be made, not at the gatekeeping role at the beginning, where the other side was allowed to present contrary evidence to the tons per acre number that only we had provided and we had given in advance with expert reports and disclosures and depositions.
Okay, Mr. Dahl, we're going to give you that 1 minute rebuttal. Let's hear in the meantime from Mr. Shellman.
Thank you.
You're welcome.
Thank you. My name's Donald Shellman. I'm from Rustler, Indiana. Second time I've been in front of you and probably my last. I appreciate this. I represent Boss Dairy and Heritage Dairy in this matter. The court's ruling on this at the time of trial was that the chopper operators could testify on what they personally experienced with during harvesting, but they couldn't give a total number of tons per bushel that they actually chopped. And what they in fact testified to was what they personally observed when they were chopping, that is, running the harvester through the fields, what they personally experienced in regards to the height of the corn, whether it was their testimony 4 to 8 foot, based upon 12 foot of corn where you get a lot more silage. They also testified about the speed that they were able to go their choppers just through the fields between 4 to 5.5 miles per hour versus 3 when it's real thick. They also testified about the soil type, testified about the lay of the land, whether the valleys and the hills where you don't produce as well, and also testified about the portions of the field that Valley View never even planted that goes into the calculation of your average for the total silage. None of their testimony was based upon what the 701 says, scientific, technical, or specialized knowledge. They had no calculations. They didn't do anything upon any type of science, any book, any publication, any theory.
It may not be scientific, but certainly there is some specialized knowledge required here to talk about the yield.
And
if you're not out there in the fields and you haven't done that before, like I certainly couldn't go out there and talk about the yield.
correct, and and thus why, the testimony was, have you done this before? What have you experienced? How many times have you done that? Exactly. And I think the mowing example that everyone can understand, including law clerks over here. You mow. Is the grass tall or is it short? Is it thick or is it sparse? Are you going to have to dump your bag 3 times or 5 times? And can you do it, on the first time? No. But after you mowed your 15th yard and doing this, can you get a sense of where you are? That's exactly what the chopper operators did. It wasn't technical. It wasn't specific. It was, and what
The part of it, though, the part of it, I think a lot of what you're saying makes total sense. I mean, they can say it was 4 feet tall and it was sandy and it seemed a little thin and all that. The part that gets a little tricky about this is when you say, well, what do you think the yield was going to be per acre? And they say 18, whatever, 18, 17, 19, right. All that. Okay. It's the kind of step from the observations that I think you're 100% right about. They can describe what they saw and what they experienced, and they could even compare it to last year. How was last year? Corn was taller, didn't seem as dry, etc. I think all that's fine. That's just based upon what they experience, what they observe. But help us on that next step.
Okay. And as to the amount.
Yeah, exactly.
It's sort of like, the grass clippings. You sort of know how much you're going to get. They know what it is because, the interesting thing is that these
they
chopper
know that because they say, one guy did it for a short amount of time, but a lot of them have been doing it for a while.
20 years.
Yeah.
Yeah, 100,000 acres. They could sense what they're getting because the one thing is that they get paid on the total amount. Just like Valley View got paid on the total amount. The truckers got paid on the total amount. They know what they're doing. They can sense that when they're doing that. And that's what that's based upon. But the true test was the certified scales that it was taken over. Because everyone who testified says, here's how you determine a yield on any crop grown in the United States or anywhere, is that you put it over the scales. And that's the same thing with silage. And that was exactly what was done over certified scales in this matter.
And so is it your position that when the court in its pretrial ruling says they can testify, but they can't testify about the total was relating solely to the amount on the scales? So that's why, in your view, there's daylight between the chopper's testimony about the average they observed was very different from the testimony about the total.
Correct. Because, the total was like 7,454 tons, and they couldn't testify to that total. And they were never asked, and there was no testimony to that point at all. There was none. And I think, what these choppers testified to was exactly what the case law lays out, based on their perception, based upon, what the inferences they got from the sense that they personally observed, based upon,
So do you see it as testimony akin to, picking up on Judge St. Eve's questions, like where you ask a very experienced nurse, how much blood do you think the patient lost, when you started treating the patient? Is that specialized knowledge, or is that, they say, well, I didn't measure it. We weren't collecting it in a bucket or anything, but I've done this for 30 years, and this person came in with a bad stabbing wound, and I think they lost X.
I mean, based upon what they personally observed, they could say, yeah, it looked to me like it was,
Is that the same? It's the same kind
3
of thing?
cupfuls or, whatever. It's not an exact total, just like they didn't do it. It was their perception about what they saw, and based upon, how they actually harvested the crop. That's what they were given. It was all based upon their perception. They didn't do a calculation. They didn't make any type of.
Is it fair to say they didn't do a calculation? When they did calculate the average per acre?
They gave an estimate of what they felt that the harvest was going to be. And by the way, the estimate they gave was consistent with every other testimony that there was about the actual harvest to it, and also verified by the certified scales. All consistent with one another.
Did you all put in? I trust you did, or I took it from the brief. Did you all put in the tickets from the elevator company?
Yeah, from the scales.
Yeah.
Yes, we did, and the calculation of, because this is a contract case, and the contract case, by the way, in the contract when the Valley View signed it, they gave their projection of what they thought the yield was going to be, and it was 18 tons, exactly right in the level of what it was. Based upon, they've done this, had a contract with them for over 20 years on the same fields. There was evidence about what these same fields yielded in the past, all consistent with what this was this year. This was the first time in 20-some years
You said there was
that were ever challenged.
evidence of what the yields were in the past that was introduced into the trial record?
Yes.
Now, was there evidence of prior appraisals? I mean, because it begs the question why Mr. Corning's appraisal was so high.
Yeah. There was other testimony about an appraisal by a crop insurance adjuster, okay, who did it on that land in the past and who did it on land right around this in that same year, and that was 16 to 21 tons, and that was done by Todd DeWeese. Other interesting thing about Mr. Corning that you referenced, if you look in there, Mr. Corning didn't do this on his basis of what he did for the insurance company. This was a favor to Mrs. Mercer because she called in asking to do it. It was done a month and a half before the crop was ready to be harvested. He didn't take the required number of samples that the standard is in the adjusting of corn. You have standards to go by. He failed to do that, in that he only took, if I may, I will tell you exactly, 10 of 17 required samples on the east side of I-65, and 15 of 34 required samples on the west side. He took 48% of what he was supposed to. Acknowledged that he didn't go in all the fields, didn't know the boundaries of the fields, acknowledged that he actually acknowledged that he didn't comply with requirements. And the testimony by Todd DeWeese, who came up and said, yes, he didn't do that. He further said that he didn't adjust it to 34% moisture, which is what the contract requires it to be. Because if the the silage has
Oh, he
30%
didn't, he didn't
moisture.
adjust moisture off his number?
No, he never considered it, in fact. It was just his guesstimation done a month and a half prior to harvest. And that's the basis of the litigation. We filed a motion for summary judgment too. And by the way, these chopper operators filed affidavits. And the affidavits were exactly what they testified to at trial. And that was done more than a year before the trial. Valley View knew exactly what they were going to say because they'd said it in their affidavits. This wasn't anything that was hidden, that came out of nowhere. They knew exactly what they were going to say. And if I may, you know, the standard that you have, even if you find the judge, committed error and allowed us to do it, you know, the standard is rather high that, you know, it has to have a substantial influence over the jury. And the testimony of these chopper operators that they complain about is consistent with all the other testimony from all the other witnesses that we had testify about how much harvest it was. And more importantly, it was consistent with the certified scale tickets that showed the exact amount.
Okay, Mr. Shulman, I think we got your point, your presentation. We thank you very much.
I appreciate it. Thank you all.
Yeah, you're quite welcome. Mr. Dowell, you got, we're going to give you your clock may have expired, but why don't you go ahead and take the minute?
Thank you, Your Honor. Kind of reverse order. The standard is whether it could have affected the jury's decision. That's in our brief. The cases Hall versus Flannery, Anderson versus Raymond. It's not that it had a substantial effect. And I would submit that, and I've got several points here. The affidavits, we knew exactly what those witnesses were going to say. That's why we moved to exclude them from saying the number. Beforehand, that motion was granted and then overturned during trial, as we lay out in the brief. Moisture, our expert covered that. He said that the way the measurement was taken was perfectly done, and that's how you get a measurement in advance. The U.S. government uses that every year, paying out crop insurance, things like that. This is how it's done. They don't trust somebody. You know, as a former president once said, trust but verify. That's why these measurements were taken.
That's not Corning's testimony. That's the fellow from the University of Wisconsin.
That's Dr. Lowers, who took his measurement and used that. And I would say that our standard, whether it could have affected the jury's decision, we're presenting a circumstantial case with expert evidence. They're presenting scale tickets. Could have gone either way. I get that. We were the only ones who presented a number, 25.7. They didn't have a number like that to attribute to these fields. If any of these harvesters wanted to come in and say, yeah, it was sandy and that corn was the worst I've ever seen, they're fine. I could handle that. In fact, one of them, he came in and said, oh, this one field, it was horrible. I mean, it was like I wouldn't plant anything there. And I said, put up the sheet, and I said, do you realize that's the field that got 25 tons per acre? Oh, well, oh. So I can handle that. But when they come in and say, oh, I think this was 14 tons per acre, I didn't get a deposition. I'd have filed a Daubert motion beforehand. All the ways that you handle 702 testimony, we were denied that. That's why I believe Valley View deserves a new trial.
Okay, Mr. Shulman, thanks to you.
Thank you.
Mr. Dowell, of course, thanks to you. Mr. Shulman, your colleague as well. We appreciate the advocacy on both sides. We'll take the appeal under advisement.
Thank you.
You're welcome. Okay, the sixth and final argument of the morning is in appeal number 243020, the United States versus Travis Thomas. Okay, is it Ms. Nipkin?
It is.
Nice to see you. Go right ahead when you're ready.
Good afternoon. My name is Courtney Knippen, and I am the attorney for the appellant, Travis Thomas. Mr. Thomas's criminal case is before this court today following a jury trial where Mr. Thomas was found guilty on all counts. We are asking this court to vacate those convictions and remand his case for a new trial based on two issues. The first is where the district court erred by failing to dismiss or at least question the first panel of jurors who were exposed to bias by prospective juror 24. The second is where the district court erred by giving the jury a copy of the indictment. I'm going to focus my argument today on the second issue because that requires this court to determine whether a constitutionally adequate inquiry was conducted of the jury in Mr. Thomas's case. For the court to answer that question, it first has to determine the probability of bias. Now, as this court has said in Oswald, the greater the probability of bias, the more search in the inquiry is that is needed.
Oswald seems very different than this case, because in Oswald, all the jurors were talking about the case and talking about how the defendant was guilty before the trial even started, which is not what we have here.
That's true, Judge, but what we have here is still a high probability of bias, and the court doesn't need to only look at the facts and circumstances of this case to find that, but it can also look at common sense. And so we know that when we are unfamiliar with something, we look to others to help make a decision. And so that means, we have a whole industry around it. So when we are unfamiliar with a restaurant, we look at a review. That goes for attorneys, businesses, hotels, anything else. And the quality of the review matters.
Why wouldn't, even if you're right that this was biased, why wouldn't the court's instructions have cured any harm here? Because shortly after the juror 24, I think it was, made the statements about the indictment, the jury told them an indictment has no evidentiary value. The final instructions to the court before they deliberated from the court to the jury said the jury has the indictment has no evidentiary value. Why wouldn't those instructions, I think the jury questionnaire itself had a direction on them, that the indictment has no value. Why wouldn't all of that be sufficient to safeguard against this?
Because there was a high probability of bias in this case, Judge, and that is why a more searching inquiry was needed. If there was no bias in this case, then I agree. Jury instructions would be fine because that is what happens in every case. But here, as in Oswald says, when there is a high probability of bias, more searching inquiry is needed. And we know there was a high probability of bias in this case for 3 reasons. The first is that the juror 24 was clearly biased in favor of the government. The second is that she had extensive knowledge and experience that gave credibility to her biased opinion. And third is that she was, in fact, persuasive, and her biased opinion was well-reasoned. And I could just take each of those in turn. We know that her opinion was biased because the judge pegged her as someone who believes that once a defendant is facing trial, they must be guilty. When she was asked whether she would give the benefit of the doubt to the government, she said she surely would, and she was struck for cause. But the bias doesn't stop there. The probability continued to rise because of her expertise, which was her long employment in law enforcement, which included her being a matron, her transporting prisoners back and forth. This is all the things that the jury heard, and more specifically, her review of cases. In her opinion, cases all the way from theft to murder. So her biased opinion had some weight to it because she had that experience, and it was obviously persuasive. And we know that it was persuasive because that's exactly what the government said. When asked why she shouldn't be struck for cause, the government said, well, her opinion was reasonable. But that wasn't the question. The question wasn't, in light of her experience, was her opinion reasonable? The question was, in light of her experience, could she be impartial? And the answer was clearly no. And that is why she was struck. And that is the same pitfall that the district court fell into, because the district court explained that, well, her opinion was unsurprising. But again, that's not the question. The question wasn't whether her opinion was surprising. The question was whether her opinion was biased. And of course it was.
It seems like you're arguing that anytime a potential juror gives a response that says they can't be fair, which happens during jury selection, that the onus is then on the court to question the entire veneer.
Well, I think I disagree with that for 2 reasons, Judge, respectfully. The first is that in these cases, it's very fact-specific, and that is why her opinion is different than some other jurors who just base their opinions on 1 or 2 experiences with the criminal justice system or just looking at the news. Again, that is why the probability was so high. The other part is that I don't believe that the jury needs to be questioned every time, but in this case, they needed to be questioned because they heard this and there was no follow-up questions. And so that is why the district court, and that is where we think the district court erred. And by saying that her statements were not prejudicial, that is where the court abused its discretion, because of course they were. And by failing to acknowledge that her statements were prejudicial, they failed to conduct any inquiry. And by failing to conduct an adequate inquiry, they failed to ensure that Mr. Thomas received a fair trial. And that is why the case has to be remanded. Because again, we have to take ourselves out of it. As people who are familiar with the system, we understand the nuances, but the jurors do not. And so they will look to someone like prospective juror 24, who has experience, who does have bias, and her opinion was well reasoned. And again, we see that in other places and in common sense and in industries. We don't give weight to something that is a review that is secondhand, that is short, or is unpersuasive. That's not the same for a review that is based on firsthand experience or is well reasoned. That is exactly what happened here, and that is why the bias was so high in this case. And so I reserve the rest for rebuttal.
Okay, very well. We'll hear from the government.
Good afternoon, and may it please the court. My name is Alex Morgan, and I represent the United States. The district court acted well within its discretion here in handling the comments of prospective juror 24. The fact that one juror voiced her opinion and potential biases as the voir dire process is designed to elicit doesn't implicate the impartiality of the remainder of the jury pool. I think opposing counsel is conflating a bit the bias for this particular juror who was dismissed for cause and the probability of bias on the remainder of the jury pool. As the district court concluded, the probability for the remainder of the pool to be biased was very low based on the nature of this individual juror's comments, which were not specific to the defendant or the investigation or any of the witnesses involved.
Can both things be true? Let me state it a little more specifically. Two things can be true. You could be right. You are right. It was not specific to Mr. Thomas. It was not specific to this investigation. It was not specific to this case. At the same time, Ms. Knippen is right that it was specific to the idea that police don't bring cases they can't charge. She did specifically name various law enforcement agencies, one of which would then be at issue in this trial. There was a witness from Rockford in this trial that she talked about. Knowing people in Rockford and talking about, her knowledge of Zion extended. She was talking about this extends beyond what I observed in Zion, because the district court did try to pin her down, okay? So two things can be true.
I think that's correct. What I'll note is that she did agree that her work experience and sort of expertise in that area were limited to Zion, and she mentioned that she had some social relationships with law enforcement in Rockford. And I just think the general nature of those comments they were so general that they just didn't indicate a risk of bias. And if you look at some of this court's
If we disagree with you and don't find the comments to be general, because Mr. Thomas makes the point, it's different from saying, I don't think I can be fair because, I've had negative experiences being stopped by police. She says, my specific work experience, I've had 3 positions in this police department, but I know people in other departments and they're just like that. So we don't think it's general. Is there still a path forward for you?
Yes, Your Honor, for 2 reasons. First, each of the impaneled jurors, including also the jury pool, was properly instructed many times on how to properly consider an indictment and the fact that the indictment did not raise even an inference of guilt. And on the written questionnaires, each of the impaneled jurors affirmed that they rejected the idea that the defendant must be guilty if he were facing trial. So on that record, I still think that further inquiry was not necessary.
Those affirmances that you talk about, those of course happened before Juror 24 spoke.
That's
So
correct.
How do we credit that as persuasive evidence that, you know, the probability, because we're talking about probability here, right? And whether a response is adequate to the probability faced. How is that persuasive evidence that 1 through 23 weren't affected by later hearing 24's very strident comments?
I agree that standing alone might not be enough, and but what I think is important here is that the jurors, the whole point of this process was to ferret out who personally held that belief, and what the jurors were affirming before hearing, obviously from this prospective juror, was that they did not share that belief, and if they may have been influenced even marginally by this prospective juror's comments, they were instructed many times that that was not the proper way to look at an indictment and the fact that charges had been brought. So I think those two things in conjunction, when looking at the record, show that the probability of bias was nonetheless low.
I want to ask you about some of our cases, because it seems that we have several cases where when the defendant moved for the entire panel of veneer to be dismissed after a prospective juror made a prejudicial comment, we held that dismissing the entire panel wasn't warranted because, among other things, the trial court questioned the remaining potential jurors about their ability to be impartial after the prospective jurors. So I'm thinking about Lott, Howard, Hernandez. So how do we look at what happened here against, you know, that fact pattern that's not here?
Agreed, Your Honor, that those cases that the government relies on, it is the case that there was some after-the-fact questioning that occurred. But this court has also been very clear that an individualized voir dire is not always necessary, and that it, again, depends on the probability of bias, and that the district court is in the best position to assess that bias as the judge that's sitting in the room and can see how the jurors are reacting. And so I think that in this particular instance, the court was within its discretion in determining that the further inquiry wasn't necessary and might even exacerbate maybe the comments that prospective juror had made. If there are no further questions, the government requests that this court affirm the defendant's convictions and sentence.
Okay, very well. Yeah, Ms. Knuppen, you have some rebuttal time. You're welcome to use it.
Thank you. Just a few points. I think just to piggyback off the idea that was raised before is that is exactly right. There is a spectrum of inquiry that can happen in this case. It doesn't need to be dismissal or nothing. What happened in this case was no inquiry at all after they were exposed to jury 24's bias. That's the issue. And again, the level of probability determines the level of inquiry. So if this court finds that, well, it didn't warrant the full dismissal of the panel, it could still find it warranted questioning. Now that questioning could be individualized, it could be to the general panel, it could, as the court recognized, exactly like it was in Hernandez and Guzman, where you don't have to point to juror 24's comments and exaggerate those comments, but you can do follow-up questions that ask, based on what you've heard today in voir dire, do you feel like you're not able to be impartial? Because there was no inquiry that was taken after they were exposed. And that is the issue here. Because if this court finds there is a probability of bias, then there is an adequate inquiry was not conducted. And Mr. Thomas is entitled to a new trial because he is entitled to a fair jury.
So your position is there's no world in which the comments can be both prejudicial and the district court's response can be adequate?
Yes, I think that's absolutely right, because if her comments were prejudicial, and they were, there was no inquiry that happened. That is, again, the bias determines the level of inquiry. But I don't think it's just a matter of whether she was simply biased. There was a high probability of bias because of her individualized, her career, her acknowledgement experience, and she, again, was very well reasoned in her explanation. The government said it, but they continue to miss the point. That's not the point. The point is, she convinced the other jurors that when a defendant has gotten to this point, they have enough evidence to prosecute or they have enough evidence to convict. And that is the same idea that they went into this trial with. Just as if you were told this restaurant is going to be great, I know they said keep an open mind, but you walk in expecting a good meal. And that is exactly what happened here. They walked in expecting to have enough evidence to prosecute, and the presumption was not with the defendant as it should have been. Thank you.
Okay. Ms. Knippen, thanks to you. I have a note here that, if I'm right, you and your colleague accepted this case on appointment from the court. We very much appreciate that. Your service, not only to Mr. Thomas, but to the court as well. And with thanks to the government, we'll take the appeal under advisement. That concludes the day's arguments, and the court will be in recess.